Someone make it make sense.
Probably a couple.
Hello, squirrel people. Happy to see you guys again. So I wanted to start out with a little bit of housekeeping. So the first thing, for anyone who hasn't heard it yet, Karen Reed's trial has been continued to April 1st. I think that kind of got glossed over because there's so much going on, especially as it pertains to Luigi Mangione. And that actually brings me perfectly into the next thing I wanted to talk about. So just briefly. So as far as the New York charges, everything that I've seen about it says murder, charged with murder. It doesn't specify what type of murder. But I've heard some people saying that it's specifically second-degree murder. Now, New York State does not just have a murder charge. That's not a thing. It's either first degree or second degree. So it's weird that there's not a specification. Now, maybe that's something that they are able to just say. I can't find the actual, any type of court filing with those charges. I'll keep looking for that. Maybe that will come out in the near future. But in the event, okay, that it is they do charge them with second degree versus first degree, I wanted to go over in New York State what the differences are, because it's different than others. Well, in every state there's differences, right? But there's something very specific about New York State. And I remember learning about this when charges were being brought against Rex Heuermann with the Lisk case, Long Island serial killer. So let's just take a look at here what the differences are so we can kind of understand. Okay, so again, this is New York State. So murder in the first degree. A person is guilty of murder in the first degree when, 1, with intent to cause death of another person, he causes the death of such person or of a third person. Now, the of a third person is interesting. I think what they're saying there is that if you intend to cause death of one person, but you cause the death of somebody else, like maybe you kill the wrong person, but that's the first element, okay? And then the subsection says either, and there's a bunch of these. So let me say it again. So with intent to cause death of another person, and so you have to have that, okay, right? So that's more akin to what you usually see in most states with first degree murder, but there's an and then there's the subsection with the eithers, and there's a bunch of those. So in other words, you have to, in order to meet the elements for first degree murder, you have to have intended to cause the death of another person, and then you also have to have at least one of these other circumstances, which we will take a look at now. So either the intended victim was a police officer, the intended victim was a peace officer, the intended victim was a firefighter, emergency medical technician. I'm not going to read it. You guys can understand the categories, right? The intended victim was an employee of a state correctional institution. At the time of the commission of the killing, the defendant was confined in a state correctional institution. So they were in custody, basically. The intended victim was a witness to a crime committed on a prior occasion, blah, blah. So again, none of these are really going to apply here. So that's why I'm not going to go into reading all of that. The defendant committed the killing or procured commission of the killing pursuant to an agreement with a person. So this would be like solicitation, right? Or, or conspiracy, right? The victim was killed while the defendant was in the course of committing or attempting to commit or in furtherance of robbery. So this is like what we see with enhancements in other states when it comes to the death penalty. Like, for example, in Brian Koberger's case, that was one that they ended up dropping. In Idaho, it was a felony murder aggravating factor, and the felony murder aggravating factor there was you're committing the crime like in the commission of another crime. And in that case, they were saying burglary, because burglary is like breaking and entering into the house, right? So that's kind of similar. So in other words, if you're also in the furtherance of another crime, so robbery, burglary, right? All that, kidnapping. To our knowledge, not applicable here. So far, none of these seem applicable to the case we have here. As part of the same criminal transaction, the defendant with intent to cause serious physical injury to or the death of an additional person or persons causes the death of an additional person or persons provided, however, the victim is not a participant in the criminal transaction. So that seems to speak to the part of the first element that we went over, where it says of a person or of a third person. That's what this sounds like, where you kill an additional person. Okay. Prior to committing the killing, the defendant had been convicted of murder. So in other words, they'd already been convicted. Okay, not applicable here. The defendant acted in an especially cruel and wanton manner pursuant to a course of conduct intended to inflicting torture upon the victim prior to the victim's death. As used in this subparagraph, torture means the intentional and depraved infliction of extreme physical pain. Depraved means the defendant relished in the infliction of extreme physical pain upon the victim, evidencing debasement or... Now, this again, technically, of course, every murder could fit this, right? But we've seen this broken down in other states. I've covered this a lot as it pertains to the aggravating factors as well, like the hack aggravator. But, here, so that the defendant evidenced a sense of pleasure in the inflict. So that's actually more specific. So that would be kind of like, I think, allegedly could apply to someone like Rex Heuermann if he is found guilty, where there's like when you've got your sexual sadists and whatnot, where there's torture, right? I don't think that's going to be applicable here. The defendant now this is really important, okay? The defendant intentionally caused the death of two or more additional persons within the state in separate criminal transactions within a period of 24 months when committed in a similar fashion or pursuant to a common scheme or plan. Now, at least with Lisk, I know that is what that was why they were waiting on, if anyone remembers, like the some of the DNA testing and stuff to come back with some of those cold, I guess they were cold cases, right? Because there were these other unidentified remains in the same area. And the same area being important, right? Because remember, pursuant to a common scheme or plan. And so what this is really speaking to is a serial killer, right? So you've caused, because two or more people, right? Additional, right? Two or more additional persons within the same state in separate criminal transactions within a period of 20. Like this literally is defining a serial killer, because again, it's separate. And then also within a period of 24 months. So that they have to be spaced out. And this is very specific. And so that was what they were, was really important when it came to Lisk, because again, I think that they, even with that case, they still at that juncture, and I don't know where it's at now, but in other words, they were seeing that this could have been the additional element that needed to be met, and that they could find that sooner and with less, and with the appropriate cause, right? That over even the torture element, right? That would probably take more time to investigate. So this was my understanding too, because again, a lot of those other previous ones, so far, right? We had we had law enforcement, if you kill law enforcement or, an EMS, or if you kill someone who's, in charge at a correctional facility, or if you're already in custody and you kill another inmate, or if you've already been previously convicted of murder. So all of those are kind of things that, again, didn't apply to Lisk, and also don't apply, to our knowledge, to Luigi. And then you have the one that's up in the air as it pertains to torture. Now, again, I think that's really more applicable when it comes to Lisk. But this is the one that I knew of in terms of, without some of those extenuating, like I just mentioned, all those extenuating circumstances, that in New York State, it's harder to be charged with first degree murder, because this is the thing that really sets it apart. Because essentially they have it set up so that you really have to be a serial killer in order to be charged with first degree murder in New York State. Essentially with this, right? So then, and then again, another one that's less common, right? The intended victim was a judge. Okay. And I think that might be, okay. The victim was killed in furtherance of an act of terrorism. Okay. And then that's the last of the ors. Okay. That's the last of the ors. And then there's another, and the defendant was more than 18 years old at the time of the commission of the crime. All right, there you go. So, so again, so essentially, just to break that down even clearer. So we have, they're guilty of first degree murder when they intended to cause the death of another person. And one of all of these extenuating circumstances, right? Law enforcement, correctional facility, torture, or serial killer activity, right? Basically, or a judge, right? And they were more than 18 years old. So when you look at all of those, you can see why So it doesn't really look like Luigi will fit the criteria for first-degree murder. And then just to take a look at this, it's an affirmative defense. So these are their affirmative defenses. The defendant acted under the influence of extreme emotional disturbance for which there was a reasonable explanation or excuse. Defendant's conduct consisted of causing or aiding without the duress or deception another person to commit suicide. Interesting. Okay, so you can see why potentially, and so again, like with Lisk, so maybe what it is when it says charged with murder, right? Again, like with Lisk, they were waiting on those last pieces of evidence as far as the additional victims so that they could then, charge him with first degree. So it looks like they're kind of doing the same thing here from what I've seen, because again, charged with just murder. So now let's take a look at second degree. All right, murder in the second degree. Murder in the second degree. Person is guilty of murder in the second degree when, 1, with intent to cause the death of another person, he causes the death of such person, and then the affirmative defenses. So this is basically the exact same thing as first degree, except that you don't have all those additional, really, they're kind of like aggravating factors, right? Like in states that have the death penalty, those other, like, let me go back to this. You can think of it this way. So when you look at all of these extenuating circumstances, as I'm calling them, all of these different elements under the subsection A, these are usually in states that have the death penalty. These would oftentimes be like aggravating factors, right? Or in states that don't have the death penalty, they're aggravating factors, and that's kind of what we have here, right? So all of these things that make it worse. Okay, so now let me go back to this. So again, this is just if you just have the intent to cause the death of another person, that's second degree. And then these are the affirmative defenses for that. It's interesting that it does not say anything about let me see. So it does mention the age, but these are under the affirmative defenses. So in other words, it looks like, so those are the affirmative defenses. And so it looks like you don't actually have to, like the 18 years old, at least 18 years old, it's not saying that here. It's not saying that that's a requirement like it does in first degree. Like here, that's a requirement that you're more than 18 years old. So in other words, so if you're under 18, let's say you're under 18 and you commit a murder and you do have any of these aggravating factors, if you're under 18, it's second degree is what it looks like. So there you go. So now we have that context. So it's, I mean, again, pursuant to everything we know so far, it's looking like probably he may not meet the criteria for the first degree. So yeah. Okay. So that's the housekeeping I wanted to go through. So now we're going to get to what we were actually talking about, which is Shanna Gardner. So let me pull this up. So while I get this pulled up here. Okay. So just to kind of talk about what we went over yesterday. So we watched the first hearing yesterday. And so that was from April 18th. This is going to be from April 19th, 2024. And so yesterday was Mario's evidentiary hearing. Today is going to be Shanna's. Now, one thing that was really interesting that came out on from the cross-examination of Shannon Day under questioning from Mr. Mizrahi, this really sunk in more as I was doing the timestamps, actually, that the whole thing about where he was talking about the CEO of Google, and it was like, what? That was wild. And so what he was trying to say there, like just to reiterate this, is that, with attorney-client privilege, right? That is waived, even if you don't technically waive it. Like if there's a third party present, doesn't count, right? So what he was trying to say, and this is insane to think about, that because a lot of this was there was the Google Drive, right? Which contained all kinds of stuff, emails or whatever, but it was all in Google Drive. So therefore on the search warrant return, the CEO of Google is listed there on that. So he was asking Miss Day, like, do you know who this person? I don't remember his name, the CEO, but do you know who this person is? She's like, no. And he's like talking about the CEO of Google. What he was trying to suggest there is that by the CEO of Google having his name on the search warrant or whatever return, that he was trying to suggest that waives privilege because that's a third party, which is just absolutely completely insane, right? Insane. So I just wanted to point that out. That seems like something you would, and that was the very first question you asked her. So that sounds like out of a state of desperation that you would even try to go there. And in fact, when they went to the argument, defense counsel pointed that out, like, you've got to be kidding me, So anyway, okay. So now we're going to get into this hearing.
I was just going to put my name on the record.
All right, hold on.
Unless you want the hand sign.
Yeah. All right, we're here for hearing a motion on case number 5 on the court's calendar, Shanna Gardner. If the attorneys will please place your appearances on the record.
Mizrahi, C. Lee Wingard, and Christina Stifler.
With the defendant, again, she is wearing civilian clothes, whereas her co-defendant does not.
All right, thank you.
Good afternoon, Judge. ASA Bias, Professor Sullivan. And
My hero. I love you, Mr. Bias. If you ever watch this or anything else I'm covering, because I'm covering a lot of stuff that you're doing. You're my hero. You're awesome. I love it.
On behalf of Ms. Gardner.
Yay!
Thank you very much. I apologize for the delay.
So this is the first time we're seeing him in person at any of these hearings.
Ms. Gardner, President.
Okay.
Woo!
Are there any matters that we need to take up prior to going forward with the hearing?
Not before we go forward with the hearing, Your Honor. There are some housekeeping matters I want to bring to the court's attention.
Okay.
Judge, I previously given you our exhibits that were marked. We are substituting exhibit L as in Lima. There should be a copy on your courtesy copy for the court on your, and so there should be copies of those for the hearing. They be admitted as.
You will be marked.
Yes, Judge. And Judge, we have no witnesses to call in the hearing on Ms. Gardner's behalf.
Okay. All right, so.
So
Thank you.
it's the defense's motion, right? So like we saw yesterday with Mario, so they would present witnesses first, but they're not calling any witnesses on her behalf. So it's looking like we're going to see witnesses called by the state.
Do you solemnly swear or affirm the testimony you give?
And guess who it is? ASA Stifler.
The truth, the whole truth, and nothing but the truth. So help you God.
Wow. All righty. All right. Starting out with ASA Stifler.
Before you begin, give me this one, okay?
Hey, please, one.
Yes, thank you.
Please state your name for the record.
Christina Stifler.
And what do you do for a living?
I'm an assistant state attorney.
And are you the lead prosecutor in state beat Shanna Gardner?
I am.
I didn't put this on the record yesterday, but could you detail for the court the amount of time approximately that you've put into the investigation of the case?
Who cares?
I've been on the case since the date of the homicide, and I've worked on it daily since then, so over 2 years.
Is there anyone in the state attorney's office that remotely has your understanding of facts and circumstances?
It's funny that he's starting out with this. He's starting out with this to try to be like, please, judge, like, look, she really knows the case. So, like, even if she willfully read attorney-client privilege information and committed a outrageous government conduct as alleged, she really knows all the details. And so, like, please, can we keep her on the case?
Actually, false speculation.
That's true.
No.
Is there any ability for anyone to quickly gain the knowledge that you have in this case?
That is stupid, because here's the thing. That is not nearly as important as making sure that this is fair, right? These proceedings are fair and that there's no prejudice towards the defense. So whether it's inconvenient or not for the state attorney's office, the nerve to ask this question.
By reading the police report.
The audacity.
Same objection as to what other people can do.
Sustained.
Oh. I want to turn your attention to the, meeting that you had with Judge Kite. Was an agreement with the state of Florida and Shanna Gardner's counsel about the searching of cell phones.
Yes,
And was, that you would not be looking for any kind of attorney-client privilege information.
yes,
And were the procedures put in place to ensure that that did not happen?
yes, there were.
Was there ever an order for the court for that to happen?
No,
Then search warrants were obtained for the iCloud information with regard to Shanna Gardner's cell phones, emails, things like that, correct?
for her iCloud account, yes.
Why was that?
We were looking for evidence based on our investigation up to that point that Ms. Gardner might have evidence on her iCloud that had been deleted from other sources based on statements of witnesses very close to her, as well as the wiretap intercepts of her and civilians speaking. We knew that there was possibly either ring camera footage, text messages with Mr. Fernandez, with her friends and family, potentially some financial information.
So the search warrant of the iCloud was done after the search warrants for the cell phones
Yes,
and done after the agreement.
yes, based on our investigation, when we extracted the phones and information we obtained during the wiretap, we knew we were missing evidence from her phones.
Was the goal of that search warrant to discover any kind of communications between the defendant and her lawyers?
Absolutely not.
Did you become aware that the law enforcement officers were looking through the iCloud and then came across what they suspected was attorney-client privilege?
Yes,
And what did you do after you heard that information?
I was notified by an ATF research specialist, Lindsay Butler, that they had been reviewing Ms. Gardner's iCloud return, that she observed a communication between an attorney and Ms. Gardner, and that she was concerned there were attorney-client communication on the iCloud. When she notified me of this, I told her to stop reading, to have everybody on the team delete the iCloud information they were looking at, and to take the iCloud return to the Secret Service to have it detainted or filtered so that those communications could be removed.
So one thing that's different too, I'll note just between Mario and Shanna. So the iCloud, it looks like there hasn't been any talk about that really as it pertains to Mario. It's really more Google Drive. So with Shanna, it's really more the iCloud communications. So yeah.
The dates of the search warrant for the iCloud, do those encompass a vast amount of time before this crime occurred?
Yes, the search warrant itself was looking for information between 2016 and the arrest of Mario Fernandez in March of 2023. The data that they were specifically looking at,
2016, can you imagine? Talk about overbroad search warrant, right? They wanted to, starting in 2016?
the time I was notified, was for date ranges between 2016 and
Incredible.
August of 2022.
I can't even wrap my head around that. Absolutely.
Did you personally ever get any kind of attorney-client privileged information in this case?
No.
And the extent of the attorney-client privileged information that you know is what you've testified to, that there was an agent that looked at something that could have been attorney-client privilege.
Yes, she just said it was an attorney-client communication. I did not know which attorney, the date, the content. She just notified me. She didn't tell me the contents of what she saw.
There's been an allegation that you were somehow part of this Taint Team. Did you ever review any information in a substantive manner to determine whether or not it was attorney-client privilege?
No,
That's not true.
When Agent Nazario called you, or emailed
Right, this part. So, okay.
you, I guess, and said he was aware of, he wanted,
Because the thing is she instructed Mr. Nazario directly to ask her if he was unsure if something was privileged or not and to come to her. And apparently on at least 3 occasions he did. So she learned the information that way.
I talked to you about his review. Was that about an attorney-client privilege now?
no.
Oh
And
boy.
what was his question?
He had completed an initial review of Ms. Gardner's data to filter out attorney-client communications. He was doing a second review, and he had, in his opinion, taken out a communication erroneously. He wanted more information about the individual recipient or sender on the other end of the communication with Ms. Gardner to, I guess, make sure that his opinion was correct.
Because he had been provided lawyers.
Yes, defense counsel from Ms. Gardner at the time, the Goodell firm, and Dreiser Hill for Mr. Fernandez had provided the state attorney's office and law enforcement with a list of attorney names, email addresses, and phone numbers that we provided, or Jacksonville Beach Police Department provided to the Secret Service. The
And
communication was not any of those individuals.
who was it?
It was an individual named Kim Jensen. She's a close friend of Ms. Gardner.
And then so you informed him that she was not subject to the attorney-client.
Correct. He advised me that he would want more information about who Kim Jensen was, and I advised him she's not an attorney. She's a quote-unquote civilian, not affiliated with the law firms, and a friend of Ms. Gardner's of many years.
Did the search of the iCloud uncover evidence inculpating the defendant in this crime?
Yes,
Did it uncover evidence that was deleted from her cell phone?
yes,
And is that probative in the prosecution of this case?
very, yes.
Is there any information that you received with regard to attorney-client privilege that you intend to use or even saw in this case?
I didn't see any that I don't need to use.
That's all the question I have.
Okay.
Mr. Sullivan, you
It's hard to see.
can, I can't.
So I don't know.
Turn your attention to the,
I'm gonna try to catch his name. I don't know who this is, and I looked on the court filings because they list the attorneys. I couldn't see. I saw Mr. Carodi, and then I saw Mr. Bies, and then I saw there was a lady. I don't remember her name, but there was not another male person's name besides Mr. Carodi and Mr. Bies. So I'm not quite sure who this is. Let me see if we can hear his name.
Mr. Sullivan, you can.
Mr. Sully.
Mr. Sullivan, you can.
Mr. Sullivan.
it's hard to see.
Yeah, I can't.
Sounds like Mr. Sullivan.
Turn your attention to the warrant from April 3rd, 2023 for the iCloud. It is true that the warrant did not mention an agreement with respect to attorney-client privilege information, correct?
Correct,
It is also true that that warrant did not mention the Taint Team, correct?
correct,
Turn your attention to the warrant for the Google account on the same day. It is true that that warrant did not mention an agreement with respect to attorney-client privilege information.
correct,
It is also true that that warrant did not mention a Taint Team either.
correct.
With respect to, you do admit that in June of 2023, ATF agent Butler called you about some potentially privileged information
In regards to Ms. Gardner,
in regard to Ms. Gardner. I'm sorry.
yes.
Oh boy.
I'm sorry, I'm not sure of the exact date,
Okay.
but yes, around that time period.
You said my representation.
Yes, I do.
Very well. So they called you, and you also agreed that that conversation ended with you representing that yourself, Mr. Mizrahi, and the chief assistant at the time, Sutton, determined that the documents were not privileged.
No, that text message or conversation was in relation to a document we found in June of 2023 in relation to Mr. Fernandez's Google return, not Ms. Gardner's.
Okay. My apologies. Same question though. You agreed that that conversation ended with you representing that you, along with Mr. Mizrahi and Chief Assistant Clinton, determined that that particular document was not privileged.
There are two separate conversations with Ms. Butler. There was a conversation which was the subject of the hearing yesterday regarding Mr. Fernandez's Google return. That was the conversation in which I replied to her with a text message after getting some information about the formatting and lack of attorney names, email addresses, or phone numbers on a document related to Mr. Fernandez. I then texted her that Mr. Mizrahi, now Judge Hutton and myself had determined it was not privileged and she could view it, and then call me back to get further information. The conversation was.
So let's stop there. So that's a yes. You did in the conversation by representing that the document was not privileged. That's a yes.
Yes, if you're referring to the conversation regarding Mr. Fernandez's Google return, yes. I just want to make sure it's clear which conversation.
Thank you. Finally, you will admit that you saw emails go around that contained information from the return of the warrant that may have contained attorney-client privilege information.
Can you be more specific about which return?
to be general at first, from any return, you agree that you have seen emails go around that have information from one of the warrant, any one of the warrant returns. You will agree with that?
The only email I received was from Ms. Butler, which was the subject of yesterday's hearing with the confidential conversation and confidential timeline attached. That's the only email I was a part of.
And you agree that you did receive those emails?
Yes, I received that email.
That's all.
Thank you. Redirect.
Okay.
Okay. Next, statement call, Agent Nazario.
All right.
Nazario.
The Taint Team, quote unquote, the one person on the Taint Team.
All right, Agent, if you'll just come straight forward, please. Raise your right hand and be sworn in.
If you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God. I do.
All right, thank you. This one.
Agent for the Secret Service.
Watch your step as you approach.
If you just make yourself comfortable, adjust the microphone.
Ladies and gentlemen, please state your name for the record.
Angel Jose Nazario,
What do you do for a living?
work with the Secret Service here in Jacksonville.
How long have you been so employed?
I've been doing it for 32 years now.
And what are your duties at Secret Service?
Right now, I am a computer forensic analyst,
And how long have you been doing that?
approximately 2 years.
I want to turn your attention to your role in the state of Florida versus Shanna and Gardner. What was your role in that case?
I was initially doing the forensic analysis of
You're gonna call himself a Taint Team? I will lose my mind.
devices that were brought to us, in particular, the extraction of cell phones, and data from cell phones, as well as a watch and a watch.
And what were you charged in doing? What was your duty? What was your
Extracting the data, and later on as the taint review for any approach communication.
So how did you go about doing the tape review?
Using the forensic software, depending on the type of data we were using, it allowed us to use search terms as if we were looking for any sort of evidence. The prosecuting attorney provided us a list of names, telephone numbers, email addresses of defense counsel representing both defendants, and I utilized those as search terms for any items of the data that we were able to recover from the device.
Did you review the content of the data that you were extracting with regard to the attorney names, numbers, things like that?
The only thing I was really looking for was communication between the two via text message, instant messaging, emails. Once I got to identifying any artifacts that meet the criteria of having those two elements, I really didn't see a need for me to go any further as far as the message is concerned.
Is that because you had been informed that the state of Florida didn't want any of that information?
Essentially,
Sustained.
Why did you do that?
we were instructed to remove any approach communication between the defendant and their counselor.
Were you ever charged with reviewing communications between the defendants and their lawyers to determine whether or not they were?
No,
So basically just put that stuff in the basket.
correct.
Was there ever a time that Ms. Stifler at the state attorney's office was in charge of what you were doing?
No, sir.
Was she marshaling the Taint Team?
No.
You did reach out to her with regard to one issue.
Yes,
Okay, here we go.
What about that?
During the course of the exams of the various devices that we had, I came across a message string that I had seen earlier on other devices. And I initially removed them because to me it appeared to be early communication. Later on, I made a determination, wait a minute, I don't think this is one of the attorneys. And I reached out and said, look, I have a text message from the defendant and another person. I don't think this is an attorney. I don't think this is privileged communication. Do you agree? He said, that's not privileged communication.
And the witness was not one of the lawyers that was given.
No,
So erroneously, you had put it aside, thinking it was a lawyer that wasn't.
initially, yes.
Did you have any other, give any other direction from Ms. Stifler with regard to your work in this case?
No.
Hold on.
Yes.
It'll be really interesting to see what comes out on cross. Because,
So during the.
Mr. Nazario was a big part of the defense's motions because in depositions, it looks like he might have said something a little bit different.
Review of these items, how many times did you correspond with Ms. Stifler?
While doing the actual team review, I think that was the only time I know that we spoke on other occasions unrelated to the team review.
That's all the questions I have.
All right, processing motion.
All righty, cross. These are quick.
Agent, prior to this case, you never received any training on being a taint
Right,
review
right.
agent, have you?
Correct.
And in fact,
Yeah. So just to reiterate, in case anyone missed it when we read the motions, he had no training, no experience. They just said, do this.
Secret Service did not provide you a manual on how to do this.
That's correct.
They didn't provide any supplemental training once you were assigned this role.
As a taint review person? No, sir.
The State Attorney's Office did not provide any training for you.
That's correct.
They did not provide a manual.
That's correct.
You told us that you were given names and numbers.
Names, emails, numbers of the various attorneys that may have had contact.
Okay, and that's fine. I was actually, let me finish my question because we talked over each other and the person cannot take down the question and the answer at the same time. So you agree you're getting names of lawyers, right?
Yes, sir.
Telephone numbers,
Yes, sir.
emails,
Yes, sir.
and your testimony is that that's all that you searched for.
For the taint review process, yes, sir.
Taint review process. Now, you told us that you called Ms. Stifler on one occasion.
Specific to the taint review, yes, sir.
You gave a deposition in this case on February
Ah!
13th, 2004.
There it
Remember
is.
that?
Yes, sir, I did.
It was a Zoom video conference.
Yes, sir.
It lasted from about 1:30 to 3.
That's correct.
You took an oath at that time,
Yes, sir.
and you swore to tell the truth,
Yes, sir.
and you tried to tell the truth. Yes?
I told the truth, sir.
You agree that your
Okay.
memory
Here we
back
go.
in February was at least as good as it is today in
So this is where is he going to impeach him? I mean, from what we know, he should be impeached because we saw those statements from the deposition and the motion, and he said something different.
about the events of the Taint Team.
Yes, sir.
Page 54 of the deposition.
There it is.
Now, Your Honor.
Yes.
I'm going to show you your deposition.
Mm-hmm.
So I'm going to read this. Question. Did you ask Ms. Stifler taint questions? Answer, I believe I did, in trying to clarify whether communication was considered taint or not, or tainted material or privileged communications. Did I read that correct?
Yes, sir, I did.
Same deposition. Question. Did you record the times you spoke with Ms. Stifler with respect to taint questions? Answer, no, I did not. Did I
That's
read that
correct.
correctly?
Yes, sir.
And please let me finish the question so you can get both. So I read that correctly.
Yes, sir.
Continuing. Question. Do you have a memory, ballpark, as to how many times you contacted Ms. Stifler about taint questions? Answer, it may have been twice or 3 times maybe. It was pretty clear what I needed, and it was more of an opinion when I asked her about the communication. Did I read that correctly?
That's correct, sir.
And the last question, just for clarification, I heard you right, did I not, that you worked on the prosecution team as a forensic extractor prior to becoming a taint agent on the same case?
Yes, that's correct.
No further questions.
I can read it.
Would you explain the deposition versus your testimonies?
Oh, by the way, so if it does that, I noticed that the court, it's the court feed. It's not StreamYard for once. So this video, and I think maybe the next ones, they sometimes have glitches. And we had some other glitches. Well, again, it's the court feed. There was some of that last night too. So just so you guys know.
To explain the deposition impeachment that the defense counsel tried to do.
As you can see,
The testimony.
yeah, there it is.
We had several conversations. To me, every conversation with regards to anything with this case, I count when we had the deposition. We had several conversations. The one that we actually had specific to a taint question was the one I discussed.
Is that what you put in the report?
Yes.
That's all the questions I have.
Brief reprocess on this last point.
Okay.
Referring to your deposition at page 55. May I approach?
Yes.
First showing you page 54 for context that I asked you about the last time. In deposition at page 55, starting at 54, line 24, I'm sorry. Question, and just to, I'm sorry, please continue. Answer, it was, just like I said, 2, maybe 3 times. Question,
There it
and
is.
just to close the loop on this, by taint questions, you mean questions about whether a particular communication was or was not privileged. Answer, that is correct, sir. Did I read that correct?
Yes, sir.
Thank you, Your Honor. No further questions.
Thanks, please.
Okay.
Right, thank you. Mr. Mizrahi?
Your Honor, may I have a moment?
Yes.
You can have a moment. You can have a moment. Get it.
Professor Sullivan, yes.
Thank you. Does Your Honor have a preference?
How's that? Has the defense entered everything that you wanted me to consider?
I believe so, just to double check. Yes, 1 through 17 is
Yes, sir.
it.
All right.
Argument?
Thank you, Your Honor. And mercifully, I will be brief. I just want to start
Wow.
with a
Argument.
statement of undisputed facts. And for ease of the court, I'm going to point the court to where the court can find these facts that are undisputed. We do know that by February 6, 2023, the prior law firm represented Ms. Gardner, and the state's attorney's office was aware of it. That's Exhibit 1. It's an undisputed fact. And everything I'm going to say is what I consider to be an undisputed fact, so I won't keep repeating that. On February 6, 2023, ATF executes a federal search warrant on Ms. Gardner's home in Washington State, and they seize numerous Apple devices and at least 1 Google Android. That's at Exhibit 2. Now, by February 7th, that's the next day, the state's attorney's office was aware that the devices seized may contain attorney-client communications, and they agreed not to look at those devices while the defense sought protective orders. And this is confirmed in Ms. Stifler's testimony from yesterday. A week or so later, on February 17th, there was a hearing where Ms. Gardner's former law firm makes clear that they had, 1, grave concerns about this Taint Team and their effectiveness, 2, the devices containing attorney-client communications, and 3, the devices that they may contain marital communications. That's at Exhibit 3. Same day, February 17th, the state and Ms. Gardner, through her attorneys, agreed that any, and I'm quoting, any communications protected by the attorney-client privilege will be removed from the devices by a non-state third party prior to download. And Your Honor will find that at Exhibit 4.
And that's why
February
it mattered about whether or not he was a part of the state in terms of like on their team.
17th and February 22nd, the state obtained search warrants to conduct forensic extractions of Ms. Gardner's Android phone and the iPhone. Your Honor will find that at Exhibits 5 and 6. On February 27th, there was a meeting between the state's attorney's office, the JBPD, the ATF, and the United States Secret Service, where they discussed the removal of all attorney-client privilege communication from the devices. Detective Johns and Lamont were in attendance. They represent the state of Florida, and that is Exhibits 13 and 7, Your Honor. There was a delay in being able to forensically extract Ms. Gardner's phone, iPhone, because it was a newer model. This information was communicated to the detectives involved in the case shortly after the February 27th meeting. You'll find that in Exhibit 7. On April 3rd, 2023, Detective Johns obtained a search warrant for Ms. Gardner's iCloud. They identified the iCloud account by using her Gmail, email addresses, and her telephone number directly related to the iPhone that they had seized back on February 6th, specifically asking for all iMessages, and the warrant simply does not mention the possibility of attorney-client communications or any reference to the tape agent or any reference to the already agreed upon protocol. No mention. April 3rd, same day, Detective Johns obtained another search warrant for Ms. Gardner's Google account, using the same mechanisms to identify her account. Again, this warrant does not mention the attorney-client communications or any reference to the Taint Team. With respect to the iCloud account, Ms. Gardner's iCloud account, you can find that in Exhibit 2 and Exhibit 8. No references. And with regard to the Google account, Exhibit 9, no references to Taint Team or possibility of attorney-client information. Ms. Stifler, in fact, assisted Detective Johns in drafting and obtaining these warrants, and Your Honor heard that yesterday in Ms. Stifler's testimony. Now, by April 26, 23, Detective Johns had received the Apple iCloud return and provided to the ATF, who circulated the iMessages in chronological order. Both Detectives Lamont and Detective Johns are on the email. Importantly, this is at Exhibit 10. Importantly, I'm sorry, Your Honor. This is at Exhibit 11. The Taint agent is not on this email. So this is information duplicative of what they've gotten already in February. And the Taint agent, I know it's referred to as a Taint Team, but there was no team. The
Right.
Taint agent
Right.
was not
Okay.
even on the email. ATF agent.
Look at her talking to Mr. Baez.
Ms. Butler also received the link and downloaded the entire iCloud return as well. This did not involve Special Agent Nazario. You'll find this at Exhibit 10. So between April 26th and May 11th, ATF analyst Butler reviewed the iMessages emailed to her. Reviewed them substantively. This is at Exhibit 10. ATF analyst Butler, and I don't mean to be just too in the weeds, was part of the prosecution team, not separate and apart, not a third-party agent, but the prosecution, the state, reviewed the iMessages that were emailed at Exhibit 10. Around May 11th, Ms. Butler, Agent Butler, or Analyst Butler, contacts Ms. Stifler regarding what she believes to be an attorney-client communication that she reviewed in the iMessages from the iCloud. That's at Exhibit 10. That's when, as Ms. Stifler testifies, she says, stop, and let's go through the Taint agent. So there is recognition that there is a Taint, there was at the time a Taint agent, and these sorts of things should have gone through the Taint agent prior to going to a representative of the state. At this point, Your Honor, it's too late. The advocates are already in possession of the information that was supposed to be weeded out by the Taint team. Now, this is Exhibit 7. On May 22, Special Agent Nazario reaches out to Ms. Stifler to ask questions regarding the application of attorney-client privilege. I'm stating, with respect to certain messages found on Ms. Gardner's iPhone, Exhibit 7, Your Honor will find that. Your Honor just heard the exchange. Today, it's one message. In the deposition in February and prior to the state coming to full realization of what the stakes were here, it was 2 or 3 times. And I asked him again, give me a ballpark, 2 or 3, he was sure. And as you heard, and I read it into the record, and the witness verified that I read it correctly, they said, we're talking about the Taint messages. Talking about your work as Taint agent. And he said, yes, 2 or 3 times. Now, despite the concerns raised during the review of the iCloud without it going through the Taint agent, in June of 2023, Analyst Butler begins reviewing the iCloud returns prior to Agent Nazario reviewing them, Exhibits 15 and 16. The problem here, Your Honor, again, is representatives of the prosecution team are reviewing material globally before the Taint team has had a chance to remove them. The proposition here is straightforward, and it's a proposition that's baked into all the doctrine of this jurisdiction and every other jurisdiction in the United States of America, that you can't be both the referee and the player.
Yeah.
You can't be both the advocate and the objective third party. That is the very purpose of a Taint team. And regarding the documents found on Ms. Fernandez's phone, Ms. Stifler, along with Mr. Mizrahi and then Chief Assistant Hutton, determined that the documents are not privileged, even though they were saved under a file called confidential. Now, for reasons that I'll get to, I don't think Your Honor even needs to reserve to figure it out factually whether or not that's an accurate statement. I would just say, as I stand here, I cannot figure how one determines something is not privileged without some basic understanding of the substance of that thing.
Right.
If someone hands me a file and I say, oh, the contents herein are not privileged. Well, I don't know that unless I know something about the contents.
Right.
I don't do it by divination. It has to be some basic understanding of the content of the thing in order to determine it is not attorney-client privilege. So I think the court can draw a reasonable inference from that. We have asked, and I just want to briefly discuss the law. We have asked, among other things, as the court knows, to disqualify the state's attorney's office completely from this case. For a court to grant this motion, the court has to find that there was either substantial misconduct or actual prejudice. Substantial misconduct or actual prejudice. Now, we wrote a full brief. I know Your Honor read it, so I'm just going to highlight a couple points and not go through the whole brief. But in the Downs case, Downs against Moore, 801 Southern Record 2nd, 906 from the Supreme Court of Florida, we find this proposition at 914. Quote, to disqualify the state's attorney's office, a defendant must show substantial misconduct or actual prejudice. This is written in the disjunctive, not the conjunctive. The disjunctive, substantial misconduct or actual prejudice, one or the other.
Remember, we've talked about this quite a bit because they've been arguing about this. Is the prejudice required or not, right? We've talked about this a lot. And the reason it's important is because the prejudice seems to only apply if they intend to use the documents at trial. And at least in Mario's case, again, remember this is where there's a distinction, at least in Mario's case, the state has said that they do intend to use some of those text message communications in trial. And in Shanna's case, there's nothing that they said they intend to use at trial. Their argument so far has been really leaning more heavily on the prosecutorial misconduct. Let me just back it up. Let's see.
The state's attorney's office, the defendant must show substantial misconduct.
Substantial misconduct. So that's what they're going for with their argument.
Or actual prejudice. This is written in the disjunctive, not the conjunctive. The disjunctive, substantial misconduct or actual prejudice, one or the other. It's a disjunctive formulation citing to Farina at 679, Southern Report 2nd, 1151, and other cases. So the court goes on to say in Downs that actual prejudice, and I'm quoting, is something more than the mere appearance of impropriety. So on the actual prejudice register, you know that it has to be something more than the appearance of impropriety. By application of simple deductive logic, then substantial misconduct must be a category that in fact includes, quote, the mere appearance of impropriety. And this is true in all federal cases.
So there's a distinction, right? So what he's saying is that the actual prejudice, right, is more than just the mere appearance of impropriety, but the substantial misconduct, just the mere appearance of impropriety is the standard for that.
Constitutionalize our objection to this by relying on the Sixth Amendment. And here's the reason why. The federal courts in every jurisdiction in America have said that the Sixth Amendment applies when there are forms of egregious or reckless violations, intrusions into the attorney-client privilege. The government has treated this as though the attorney-client privilege is nothing more than a rule of evidence that we can sort of play fast and loose with. That is not true. Doctrinally, both at the state level, doctrinally at the federal level, the courts say that this rises to the level of constitutional infraction. And this is our argument. Now, more doctrinal support. One of the reasons why I said Your Honor doesn't even need
You're doing a great job. I still wish Mr. Byers were arguing this because, you know, I love him.
to sort of try to resolve the difference between the testimony you heard and the email that you have in an exhibit, or the text message you have in an exhibit that says there is no attorney-client privilege, right? That, again, presumes that someone knows something about the content,
Right.
that someone is the state, in order to make a determination of the absence of something, right? I can't say, hey, there's no water in this carafe. No water in this carafe, if that's the right word. I can't say that unless I look at it and see, or jingle it or something. I have some basis to make a claim about the absence of something, and we are missing that here. Having said that, I point the court to Bogle, and that's at 655 Southern 2nd, 1103, where the court affirms that in Florida, this again is the Florida Supreme Court, that in Florida, and I'm quoting, we have stated that the appearance of impropriety created by certain situations may demand disqualification. We have evaluated such situations on a case-by-case basis. And then the court goes on to give examples of cases in which it has disqualified the state's attorney's office for violation of the attorney-client privilege. Now, here it says that the appearance alone is sufficient. We've cited to some federal cases in the brief. Sullivan is one of them, which I'll talk about a little bit
And that's
later.
where you get to the Sixth Amendment. And when we went through when we were reading the motion, I actually, before anyone mentioned the Sixth Amendment, that's what I highlighted that. I was like, well, yeah, because the thing is that the mere appearance of impropriety is enough to make someone who's a criminal defendant feel like they can't trust that what they tell their attorney will stay between them. And then what you get into is an issue of potentially ineffective assistance of counsel, even if it's not due to their counsel's fault, right? But essentially, if the counsel can't effectively assist them because the client can't trust that their communications will be kept private, then you're getting into the Sixth Amendment violation where, you know, the right to effective assistance of counsel. So
through the history of the relationship of the Sixth Amendment and the attorney-client privilege. And one of the common threads in federal court is that these courts are suspicious, presumptively, of taint teams. Why? A few reasons. One, they're prone to error, even if not intentional. Two, also are prone to intentional error. Three, they give the appearance of impropriety, and that does a disservice to the public's view of the integrity of the criminal legal system. Why is that? Not my words, the words of the federal court, is it appears to an average, reasonable third-party citizen that the fox is guarding the henhouse. Having said that, the federal courts say we have to be very, very careful when we're using these taint teams, and because of that, state Supreme Courts like Florida say, even the appearance, Your Honor, even the appearance of impropriety is a violation that touches and concerns and implicates the Sixth Amendment. So what we do have in evidence that's undisputed is that the taint agent called the very prosecutor working on the case about potentially privileged information. In no universe should that happen. Yesterday at the hearing, my brother at the bar from the state's attorney's office said something to the effect that, oh, this office did everything we could have done. No. Here's what should have happened. Hello, State's Attorney Stifler, I have a question about something that is potentially privileged. I'm sorry, agent, I cannot talk to you about that. You are the taint team. I can't have a discussion with you. But what we do know is that there was some discussion, and there was even a reply that it's not privileged. The advocate cannot be the one that's making the privilege determinations. That flies in the very face of the 100 years or so of attorney-client protections and its relationship to the Sixth Amendment and all the jurisprudence therein. So there is no doctrinal support. I respectfully suggest to Your Honor, none, zero doctrinal support for the proposition that the attorney on the case can do anything with respect to the determination of whether something is privileged. That indeed is the purpose of the team itself. Now, the other point that I want to bring out with the Bogle case, and there are others, that the disclosure of confidential or attorney-client privileged information in and of itself is prejudice. So the court doesn't have to wreck its brain about, well, what did they see? What exactly was in there? How much did they look at? Doesn't matter. The disclosure itself is enough to trigger the protections of the Sixth Amendment. So let us look at Castro, for example. Castro Supreme Court case, Florida Supreme Court case, 597 Southern 2nd, 259. This is at page 260. And I'm quoting, turning to the present case, we cannot say that the integrity of the judicial process has not been brought into question. A little further down, court says, nonetheless, and I'm quoting, nonetheless, the state argues that disqualification should not be required absent the disclosure of confidential information or other affirmative showing of prejudice. So the state in its briefs admit that disclosure of confidential information is prejudice. Notice how the court phrases it, the disclosure of confidential information or other prejudice. So that's prejudice or other prejudice is required to be shown. Now, court goes on to say that the rule established by Fitzpatrick prohibiting the disqualification of an attorney from either providing prejudicial information relating to the pending criminal charge or personally assisting in any capacity in the prosecution of the charge. So the court disagrees with the government's admission, at least with respect to what they wanted to the court to conclude, because they said that there was not disclosure. Here we have disclosure.
Yeah.
That's not an issue. The government wishes to argue on the margins about how much disclosure, what do we see, what do we not see? It's not what the doctrine says. The doctrine says that disclosure, period, is a problem. So the court, relying on the Fitzpatrick case, says that providing prejudicial information relating to the penal criminal charge or assisting, so just providing can be sufficient. So this is the analytical framework that I respectfully suggest that the court deploy in its analysis when thinking about the case. And I'm relying as persuasive authority on a case called Sullivan. Very strong name already, so it's a good start. It's a good start with this case. It's called Sullivan.
I just wanted to say for anyone who's like persuasive authority. So persuasive authority. So, we've talked a lot about mandatory and binding authority, right? So that would be any authority, so case law, that comes from a higher court level. And right now we're in the trial court. So that in the state of Florida, it would be the Court of Appeals or the Florida Supreme Court. So that would be, mandatory authority, right? Or the U.S. Supreme Court would be mandatory and binding authority, of course, for every court. So when they say persuasive, it means it's not mandatory, but you can consider it. So this could be case law from another state. That's probably what it's going to be.
Sullivan, and it is from the United States District Court case, because as I said,
okay. So I was going to say the other thing it could be, usually it's case law from other states. We see that all the time. This is the less common, another option here. So when you're looking at federal, so this is a United States District Court case. So this would be federal court, but not Supreme Court. So that's why it's persuasive.
We've constitutionalized this objection, and I hope it's not the case, but this is may have to get resolved in the federal courts at some point. But it is at 2020 Westlaw 1815220, and it's an order granting in part the defendants motion to suppress or to exclude a bunch of electronic data that was provided to the prosecution. So in the Sullivan case, Your Honor, here are the facts briefly. Some of it's technical, and I don't know all the names of this, but there was a data withdrawal of some electronic data, just like in this case, from iCounts and iClouds and so forth. There was some subset of that information that the taint agent could not figure out how to open. So the taint agent then, instead of Googling it or whatever and figuring out how to open it, classified it as non-privileged and gave it to the prosecution, right? Now, the prosecution, by simply doing a Google search, figured out how to open it. And the process was to forward it to an iPhone, and then you could open it on the iPhone. The evidence was that the prosecution never did that. And the court said, I will grant that the prosecution never followed through and did that. But Sullivan says that it really doesn't matter, because once the Taint Team forwarded this information to the prosecution, that implicated Sixth Amendment concerns relative to the attorney-client privilege. So what the court ruled was that the government, in effect, seized privileged documents. And that's when the Taint Team emailed it, right? Just like in this case.
Yeah.
When things were emailed to detectives, to prosecutors, the government was in the vocabulary of Sullivan, constructive possession of what may well have been attorney-client privileged information. Sullivan rules that that is a no-no.
No.
A little more eloquently, the court says that basically the fact that the government took possession of this information alone, that fact alone, is sufficient to attach liability, one, and to sanction, to impose a sanction on the government. Basically, the reason is if it didn't, then, and if there is no sanction, then what is to stop any prosecutor
Makes sense.
from just gathering up a bunch of putatively protected information and deciding whether or not they're going to use it, whether or not it's attorney-client privilege, whether or not it's helpful to them. The Sullivan Court and other federal courts, and the cases are cited therein, say that's not how it works. There has to be a wall. It has to be some sort of third party that's not in communication with the prosecutors. You can't have them emailing stuff over and around and through the wall. This is very important, Your Honor. In the Sullivan case, the court admitted that the defendant was not prejudiced in the traditional sense. No prejudice, but the sanction was that we're going to suppress that entire subset of documents that were pulled out. So these I messages that were pulled down, we're going to suppress those because of, in the court's words, and I quote, the reckless and grossly negligent, end quote, conduct demonstrated by the Taint Team. I would argue here, we see the same thing, that the Taint Team, taint person was reckless and negligent by even asking the prosecutor what to do about a putatively protected document or set of documents, 2 or 3 documents as they relate to Ms. Gardner. Now, I feel badly for the agent because the agent had not been trained in this.
Right.
This
is what I speculated even from the get-go, that I'm like, is he going to say throw under the bus? I literally said that. I was like, I feel like they aren't blaming the agent because the agent was thrown under the bus by the state. And let's see if he's going to say throw under the bus.
Throw somebody in and give them a
Throw somebody in. Okay.
Say, hey, you're a Taint Team.
Right.
And give them some emails and tell them to go. He should have been.
Right. Yeah.
He should have been instructed, school, given a manual, something that Taint Team needs, that you can't taint. You cannot taint the prosecutors. But that happened. That's the analysis in Sullivan. And this case is more than Sullivan, so we're asking for a greater remedy.
Right.
Because under the cases I cited in Castro and Bogle, there was prejudice in the disclosure itself. This is very consistent as Your Honor knows, with other Sixth Amendment jurisprudence, and specifically, I'm thinking of Strickland against Washington and its progeny. As the court knows, the progeny of Strickland divides Sixth Amendment effective assistance counsel into two lines of cases. The first line, you have to show some form of actual prejudice. But the second line says there are certain things that are tantamount to not having a lawyer at all. And we, Supreme Court, U.S. Supreme Court says, we don't care if there's a showing of actual prejudice. We presume prejudice. And this is the same analytical framework that Sullivan and other federal courts are working through with respect to the with respect to the attorney-client communication issue. It is the exact same analytical framework that in these certain instances, when attorney-client privileged information is disclosed, that becomes prejudice in and of itself, prejudice per se. So get quite familiar, Sixth Amendment doctrinal moves that go down two lines. I suggest to Your Honor that this is very similar to that. If the court will allow just a very brief indulgence to talk to co-counsel. Thank you.
Yay! Always to talk to Mr. Bias. I love that he said indulgence because that just makes me think of Murdoch. I beg the court's indulgence was amazing, and love that he said that. Talking to Mr. Bias, love it. Mr. Crody's also joining in.
So, Your Honor, to be clear on just a couple things where it may not have been clear on. One, as noted in our briefs, the relief we're asking for is the disqualification of the entire office. The suppressing the iCloud messages is an alternative in the alternative argument, but our main argument is described in our brief, and we think it's justified by the cases. Is to disqualify.
And we talked about that too when we went over the document, that they have the different options, right? Like, it's like the compromises, right? Like, okay, if you're not going to remove the office, you can suppress the information.
By the entire office. And second, just to point out that by Ms. Stifler even answering the telephone.
I knew it, and I was like, well, wait, he hasn't addressed the prosecutor yet. Yeah, so I'm glad that they had a little chat, and because he needed to address this part too, right? Because the remedies, right? That was something that Mario's team was, they had the state had said that they didn't suggest enough remedies or whatever, and so the remedies are important because if you're asking for sanctions, right? This is what they're talking about. These are the sanctions, right? Whether they remove the whole office, whether they suppress the information, or whether they remove the prosecutor, those are sanctions. And those are remedies for what the defense is saying is this, severe misconduct. So, what else was I going to say about that? I don't remember. Anyway, maybe I'll think of it.
And this is uncontested, following is uncontested several times from the Taint agent. Again, gives this appearance of impropriety. And that's how we get to, on either side of the ledger. Either it is negligent and reckless on the Taint team, get you to disqualification, or willful on the side of the government's office by taking these calls and accepting these calls. I don't believe I've ever talked this much without interruption in any sort of argument. And so if the court has any questions about anything I've said, I certainly would welcome them.
He's like, I'm shocked that you let me talk for so long. But, it's a good point because we pointed out yesterday, for anyone who saw it or for anyone who didn't see it, I thought it was really interesting that when it got to the state's argument, within like one sentence, the judge interrupted him and was like, hang on, right? And so it's really a good thing, right? Because he's right. She did not interrupt him once. That is really surprising. Because that's pretty unusual, but that does usually when they interrupt, it's like, at least when it comes to this particular case, right? What we've seen so far, it's usually because it's like, hang on, you're saying something that like is contrary to what you said before. And basically the judge is usually seeking clarification so that they can properly understand the context of whatever they're going to argue before they go ahead and argue. And like, that doesn't make any sense. Or if there's something that they're saying factually that is like a contradiction, like that happened yesterday as well. So, I mean, if you're just letting them go ahead and argue, it means you're not seeing any issues there. So,
My best to be responsive.
Yes, sir, I do. You ended your argument, that's where I'm going to begin. You said that this, in discussing Sullivan, you said that this case is so much more. Factually, and what have you presented, tell me why. Because I understand the disclosure issue, but why do you believe this case presents something more than what happened in Sullivan, where they essentially did something similar and it was just suppression by that court?
Because the state's attorney's office made a substantive determination as to whether this information was privileged or not. That did not happen in Sullivan, and that strikes me as a difference with the distinction and with meaning.
I see what you're saying.
So it's up here. That's based on the text message that was sent from Butler to ASA Stifler, and then that was sent back. That was my understanding from the Fernandez case, and I know that you've adopted pleadings to the Fernandez case. Tell me, number one, if you believe I have the authority to kind of wrap these two together in that way to then disqualify on Ms. Gardner. Number two, do you believe this court's decision would impact if I disqualify hypothetically on Fernandez, that I would then have to disqualify on Ms. Gardner because they've been joined by the state of Florida?
So to answer the first question, of course, Your Honor has authority to do that. There's nothing in the Florida case law that I've seen that would prohibit Your Honor from exercising the court's authority. This is, I'm making another constitutional issue. This is under the Fifth Amendment, and this is the court's supervisory power when there's been a constitutional violation. So that's the technical basis for the court's authority to exercise its supervisory jurisdiction. As to disqualification with Ms. Gardner specifically, here it is, Your Honor. We don't have, and the court doesn't have everything that was disclosed. I would ask the court to credit the deposition testimony of the Secret Service agent who said, I called on 2 or 3 times about these events. And there we have exhibits that show you, and I'll get the exact exhibit numbers. There are emails flying around, Your Honor, that office, 3, 4, 5 different people on it that contain the information in dispute. That is enough there to show the disclosure as regards Ms. Gardner. That is enough there to show the negligent and or reckless behavior by the Taint agent who just simply did not know any better because he wasn't trained, and admitted even picking up the telephone and having the discussions with respect to both people are sufficient, because if nothing else, it gives the appearance of impropriety. And the test there is a reasonable third party.
It's okay.
So you take any reasonable third party and say, hey, the guy who's supposed to keep this information away from you is calling you about the information that they're supposed to keep.
Right. I mean, because logically it defeats the purpose.
Away from you. So, I mean, lawyers talk like that, but the standard is for a reasonable third party. Does that present the appearance of a conflict such that it would satisfy the integrity of the criminal legal system and the perception of the court? What are the the other argument here is the government may well decide to use evidence in the Hernandez matter against Ms. Gardner, so that applies as well.
Right, good point.
So is that what your answer is to the interaction between the two cases and you're adopting Fernandez's motion?
Yes, absolutely.
Yeah, the way she's asking questions here at the end of his argument is kind of reminiscent of a, what you hear at like an appellate court level or a Supreme Court level, where, you present your argument and then they ask you pointed questions. Which helps. So there's like an engaging in discussion back and forth, which I really love from just like the intellectual perspective of it.
Okay, so number 11.
Yeah, I do like
yes, 11. That's when there was a string of emails, Exhibit 11, going around the office. That's your disclosure. At the time, April 27th, they knew, back in February, they knew that there was a Taint Team or Taint person established. Nonetheless, these emails went around. So yes, my answer to the question about incorporation is both Fifth Amendment supervisory power and the fact that this evidence the evidence may bleed from one case to the other. That's certainly a possibility.
Yeah.
And so the court can and should consider both
And
cases.
that's something we haven't talked about a whole lot in these hearings. I'm glad they mentioned it. But you know, this the potential that, of course, any evidence that they collect from one defendant could be used against the other, right? So I'm glad they brought that up. So in other words, the issues that Mario's team brought could also be applicable to them because they could be using that against Shanna.
Thank you very much.
Thank you, Your Honor.
Okay.
Mr. Mizrahi?
Mr. Court,
All right. It's time for the state.
through all of that argument, through everything that we've seen in this motion, there is not one case in any state court, any federal court, that even remotely stands for the proposition that if a state of Florida government entity has, through a lawfully issued search warrant, knows of the fact that there may contain attorney-client privilege, that possession of those items is grounds for the remedies that the defense is asking for. I appreciate defense counsel's withdrawal of the remedy of the dismissal of the indictment, because that is obviously not appropriate. And obviously, based on this hearing, are withdrawing that from the motion. So the question before Your Honor is whether or not the state attorney's office, specifically Ms. Stifler, should be, like I said, what that only thing asked for is a disqualification of the entire office. And there is no support in the law anywhere for what they said. Well, you would have heard it. What the court heard reminds me of something that is argued in college football over and over.
Oh
and over.
God, why?
It has to
Why?
do with the concept of an A team beats B team.
Oh my God, why? He can't not be. You know, think about it this way too, guys. Like, you didn't have. Okay, so as far as the defense, Mr. Sullivan, right? Very, very sound argument, right? And they're alleging prosecutorial misconduct. But what you didn't hear him do is like make jokes about or be condescending about the argument in terms of like what Mr. Mizrahi is doing is like saying like that's condescending about his ability to argue. He's saying it's like a argument you hear at a football game, and it's just like why are you can attack the argument without attacking the person, you know? It's just really off-putting.
And B team beats C team, and C team is the national champion. Then the A team is also the national championship because they beat the B team, they also beat the C team.
I don't even know if that
Florida
makes
and
sense.
Miami years ago in the 80s, where Florida beat the University of Miami.
What is happening? Now he's actually taught sports ball? What?
Lost multiple games along the
Oh
way,
my
and
God.
Miami became the national champion.
Great.
So all the other
That's
teams
super relevant.
in Florida claim they should be national champions as well. Their case law analysis is that they are taking and picking and choosing lines for particular cases that don't have anything to do with this case. This is not a constitutional system at issue, and they're quoting 3850 and Strickland law. There is no authority for
No
the
defense,
situation
yeah.
facts that the court has, which is that Ms. Stifler was never provided, no one in the state attorney's office, frankly, no one in law enforcement ever read the
Frankly, no one in the
substance
planet.
client communications in this case. While it is true that download existed in their possession, the court is well aware of a myriad of situations under which the state of Florida or law enforcement is in possession of something that is attorney-client privilege. For example, law enforcement can serve as a search warrant on a person's home looking for particular documents related to a crime. And the seizure of those documents, after the review of the documents, let's say they're looking for a contract, and they're looking for the specific contract with regard to the crime. Within a home, and they have probable cause and judicial authority to look. If they were looking through the documents in the home and came across an attorney-client privilege document, that does not disqualify law enforcement because
He's doing this. He made the same argument yesterday and annoyed me yesterday because none of this is relevant. None of this is what's happening here. And Judge Kite has got to be just like I'm like, okay, you can skip this part.
Because what they would do, and what they should do, is exactly what we did in this case.
And notice, where's the case law? Like, look at the difference too, just in terms of like between the defense had this guy just seems like he's just improvising, right? And just like talking versus where you had Mr. Sullivan clearly had an outline. He had his case law ready to go. It was linear. It was logical. It was sound.
Which is to remove that document, not read substance. And
Yeah,
therefore,
the defense called no witnesses actually.
I violate attorney-client privilege. They have made no showing that their attorney-client privilege was ever violated by anybody. And I guess the argument from defense is that the defense attorneys should be the one conducting the search and review of everything because they know what case is.
Can
There
you
is
say
no
that?
way for any
Oh my
human
God.
being in the world, whether they've been trained on a manual or not.
Literally,
to know
they
whether
said third party that they, oh, dude.
item is taint or not unless you speak to the attorney and the client. What you can do is your best efforts to not read communications that are obviously between the attorney and the client. You know, the only
Where's
way
your case law, man?
we could ensure that was by Ms. Stifler providing the names of the attorneys, emails, the numbers to the agent, saying, please do not look at these conversations. The only thing that has been uncovered so far is the fact that the state agent called and said, oh, I thought this person was a lawyer, but I really don't think they're a lawyer. They're not on the list. Am I able to look at this person's? Because and then obviously they're not a lawyer. So how could it be part of our process for removing attorney-client privilege? A couple of corrections as to what defense counsel said with regard to on the exhibits. Number 11, when we're talking about emails flying around, the Stifler is nowhere on those emails. As soon as the state attorney's office became aware that there may be attorney-client privilege within the iCloud return, we immediately began the process of sifting out the attorney-client emails by then sending to the tape agent again. And remember, Your Honor, the obtaining of those search warrants was done after the agreement with regard to the phones. That's the situation where the law enforcement was aware of the agreement with regard to the phones, but not aware of the agreement with regard to the iCloud, which makes logical sense because, as I pointed out yesterday, we are not serving search warrants on the defendants or their lawyers. We're serving search warrants on third parties that the defendant has acquiesced to have control. And so once we realized that that third party may contain some attorney-client privilege, we took the steps necessary to not review any substance having to do. I also would like to point out that although I thought Agent Nazario was very clear his under testimony here today, that he did have multiple conversations with Ms. Stifler, but that the only one that addressed the specific question about a specific piece of evidence was the one with regard to whether or not text message or email was to a lawyer, and that is actually documented in defense number 14. So within defense number 14, his report indicates that that was the conversation, so that actually corroborates his testimony. And certainly him saying 2 or 3 times is not indicated in his report, only the one time is indicated in his report. Regardless, there was never, as his testimony always said, that he never discussed the substance of anything with the state attorney's office. So unless the court has any specific questions, there is no support anywhere in the law for defendants' requested remedies, and we ask the court to deny the motion.
Okay, you seem to be making a distinction between the agreement that was made on the cell phone devices and the iCloud. And the way that I understand it is the iCloud from Stifler's testimony from yesterday, is the iCloud was sought because it potentially contained more information than what the potentially would be on the cell phones.
It could contain deleted information from the cell phones, correct?
Okay.
There would be, I'm sorry, Your Honor, I have to explain that, but there would be no reason for us to think that the attorney-client privilege would be on the cloud, because why would you delete attorney-client information from your phones? They told us it was on the phones, we sifted it out, and we're looking for the things that are substantive with regard to the investigation of things on the cloud. So when we're looking for things that are substantive of the case involving the cloud, and then we see attorney-client privilege, we stop and go through.
Okay.
It's just an explanation as to why law enforcement is looking for the criminal process.
That's what I'm trying to understand, because wouldn't the cloud potentially have what's on the phone duplicate, meaning that it might be on the phone, it might be on the cloud, depending on how a person would back up their data from the phone, and then potentially more information that would be contained on the phone.
Correct.
So why is the state of Florida drawing a distinction in the agreement for the cell phone, knowing that they're in the cloud, it contains duplicate plus more?
I'm explaining why law enforcement was looking at it before we went through the page. I'm not making a decision. The state of Florida never wants to look at attorney-client information. We don't want anyone to, but we can get in possession of it, and when we see it, we get rid of it. That's the nature. So I'm not saying that the agreement that we made, Your Honor, is that we're not going to be looking at attorney-client privilege information, and we continue to do. I don't see that.
That's what I'm trying to understand, that if that was what the explanation was, is why they, as law enforcement, would go through it initially. And I'm specifically trying to address the defense allegation against the state that.
So you can tell a big difference in the questions that she's asking, because she's taking a lot of issue with some of the stuff that he's saying, and there's also a lot more back and forth, right? And like I said, he provided no case law.
It's misconduct. So if the cloud potentially had duplicate plus more, why would that go even more so over to the taint as opposed to going to law enforcement?
Yes,
I decided it should have gone there from the beginning. I'll provide an explanation to our intent as to why it did not.
Oh boy.
Okay.
Misconduct.
Yeah. Okay.
Because every single case that exists is the state or the government going and getting this stuff intentionally. And that is not the case, and evidence supports that. As soon as we became aware of any attorney-client privilege, we stopped it. The law enforcement, as you heard from the testimony, the second the state attorney's office got wind that the Google return was containing attorney-client information, we shut it down and sent it to the page. Law enforcement was going through it thinking that the phone agreement existed, and then when they said, "Oh, we have attorney-client in this," they let us know to their credit.
Okay.
And no one else saw anything other than one agent and said, "Hey, I think I should."
Well,
Can I ask Professor Sullivan, I'm going to ask you, same question. What do you see the interaction between, obviously, Ms. Gardner has adopted Fernandez. What do you see the interaction between the court's rulings in these cases?
I don't have a specific case law research done on that particular issue, but my instinct tells me that they're joint. One goes with the other.
Okay, so.
If I'm able to supplement that, I will.
Okay.
As far, but I think that they're joined by an indictment, and one, we're picked off one, I think that we're picked off.
Does that impact at all the argument that you've given me thus far related to what happened in Ms. Gardner's case in light of what happened in Mr. Fernandez's case?
I don't understand the question.
All right, so in Fernandez, the issue is different. There are two documents that were sent over. One where the state concedes that you saw/viewed it and believe it to be evidence. The other one, it was sent, however, not reviewed, is the way I understand the evidence.
Just the evidence, the one that was sent, not reviewed, we were made aware generally of the contents,
Okay,
but we did not review it.
and so my question is, if the state's position, if we follow your gut in saying that these two defendants are joined, does that impact at all the arguments that you've made in the Gardner case related to that there's no support for disqualification?
question.
If they're joined together and the cases are potentially.
He knows what you're asking.
He
He doesn't know how to answer it.
Intends to try them together.
Clear.
Does that impact your argument related to anything that you've argued thus far?
Obviously, the state has argued that we should not be disqualified from Mr. Fernandez's case, so all those arguments still remain in place. And I would make all those arguments again. Obviously, there's less, in the state's opinion, there's less, I don't know if you call it taint, because I don't think the state has done anything proper. But there's, obviously, Ms. Gardner has less of an argument since her attorney-client privilege, according to the lawyers, was never pierced. They admitted that. So, that's all I can say about that. I don't know about the answer as if the court finds us for Fernandez, is that automatically, even if there is no.
I know.
Violation of Gardner, because they admit it. We may have not had any of this information, and because they're joined, I don't see how one attorney's office can handle one case and the other attorney's office can handle the other case. Not for legal or attorney-client privilege reasons, but for logistical reasons. Nothing makes any sense. Logistically, to have two different
What?
attorneys
What is he talking about?
handling the same case. So obviously, there's a significant amount of evidence shared between them. So I mean, I think for practical purposes, that makes sense. If they're not for legal.
Okay.
What is your argument related to disclosure?
There's no disclosure. I'm not sure, we had yesterday, we had a huge discussion about what the word confidential is. I don't understand what the word disclosure is. I read it as possession. The law enforcement had possession of attorney-client information. There was no disclosure of attorney-client information. So I think
So you're,
there is no disclosure in Ms. Gardner's case whatsoever. Asking questions of the state attorney's office about whether a person is or is not a lawyer, or informing the state attorney's office that communications between a client and a lawyer exist, is not disclosure of attorney-client information.
I mean, what it is, this is so stupid. That was in reference to the emails that were sent out to everybody with the information in it, which they talked about earlier. There was like, in other words, there was more like dissemination with Shanna's materials than there was with Mario's. So
We know that, attorneys, that's what we were searching for, to eliminate that information.
he's still talking. There's no question pending. Yikes. And this is what you know what he's doing? He reminds me of like when a defendant takes a stand. Like she asked him one question, he answered it, and then there was a pause because she's like looking at things. But then he does that thing like, I'm going to keep talking to fill. So then he just kept talking to fill the silence, and then he did it like I think a third time. And now let's see what happens. There's another silence. Maybe keep talking or stop talking again. Oh boy.
The argument by the defense that there was misconduct related to not following the taint procedures on that iCloud return.
Well, remember, the agreement was to go on to the funds. Of course, the state of Florida is always interested in not looking at attorney-client privilege. And so, once we were made aware that there was attorney-client privilege within the cloud, we did those procedures. Should we have done those procedures from the very beginning? Sure. That would have been wonderful. But misconduct is we're trying to do something that we're not entitled to. We're trying to gain an advantage. We're trying to do something nefarious in order to discover something. And the only reason why
I will say though, even if you give him that, even if you give him that, even if you were to say, okay, I mean, I'm not saying I agree with this, but just for the sake of the argument, even if you were to say, okay, maybe it wasn't willful, right? Maybe it was just accidental, right? Which is what he's saying. But even if you go with that, but then when you apply the fact that the evidence that they do intend to use at trial, and as it relates to what Mario's information, right? But that they could intend to use that against Shanna, then you still get to prejudicial. Even if you say, okay, it wasn't willful, because remember that there's those two different, as per the case law, right? It's with willful and the misconduct, you're looking at the even just the appearance of impropriety, and then with the prejudicial, you're looking at it is what was it? With prejudicial, what was the wording? I think it was just that it goes past the mere appearance of impropriety into it is impropriety. So yeah, it's just interesting because I feel like no matter what, he can't fully clear all the arguments made by the defense.
Well, that cloud was because the phones didn't contain information that should have been there. And so we got the cloud, and we were like, oh gosh, it's going to back up some attorney-client stuff on the cloud. We got to go through that. So I mean, this is misconduct is not a realizing that we should have done something earlier than we did. That's not misconduct. Because as soon as it would be misconduct if the state of Florida continued to look through those things and said, well, there was no agreement as to the iCloud, so we're going to look through all these things. That would be misconduct. We need to do that.
Right. What about the tape agent calling Stifler and her?
Yeah, right.
So that's not misconduct in any way, shape, or form.
Oh my God.
You have to understand
Right.
that all these cases, everything they're cited are situations where you're serving search warrants on accountants' offices, security exchange stock deals that are fraudulent. You're serving subpoenas and warrants onto lawyers and going through their law stuff. And that's not of the change. Someone is actually going through a particular item of document or a voice call to say, is this attorney-client privilege? In this particular case, we didn't look through any of this stuff. It was, if it's addressed to a lawyer, many of those things, I know the court has seen it, are going to be scheduled, are going to be things that would not be considered attorney-client privilege. But the state of Florida had no interest in any of that. We weren't looking through any communications between a lawyer to determine whether or not it was confidential or not, whether or not it was privileged or not. We were looking to dump all of that stuff into a separate basket so we wouldn't look through it. And calling and saying, hey, is this person a lawyer? is not asking us to review whether something is privileged.
Why did you ask me to do it?
The defense asked you to do it. Why ask you to look at it?
Yes, you wanted me to look at the substance of these to argue prejudice. So I'm asking you, if that was the state's position, why?
Well, the
you
other
asked
thing is
for it to do
this.
that?
The other thing is this, that the way that conversation went down was this. Angel Nazario went to the prosecutor and said, hey, I have a question about something that's attorney-client privilege. She didn't know what the question was going to be before she said, yes. Okay, go ahead. Right? So sure, okay, maybe the fact that he's like, oh, I made a mistake. I thought it was a lawyer, but they're not. Fine. But the thing is she didn't know that until she said, okay, fine. I can help you. What's your question? And that could have been something else, right? So I don't know.
If the state was not going to argue that these things were not prejudicial.
I don't know if they're prejudicial or not. Here's the argument is twofold. One, if the argument, this is more with regard to Mr. Fernandez than it is to Ms. Gardner.
He said they adopted the
Right.
motion.
So if the possession of, because that's what we're talking about, if the possession of attorney-client privileged information was the nature of that attorney-client information was innocuous, was scheduling matter, was not maybe even attorney-client privilege, we don't know, the court can make those findings and say, even if the state should not have uploaded to Nextpoint the attorney-client privileged information, the fact that it was up there, the court has independently reviewed and finds that that does not prejudice the defendants in any way because it's scheduling matters. It's attorney retention matters. And then the court can make a finding, not only was the state not improper because we didn't read any of the stuff, but even their possession of it would show that it doesn't impugn the integrity of the criminal justice system.
Is that the one you're asking me?
I'm asking you to make, yes, both. I'm asking the court to say, one, we have committed no violation because possession is not a violation. Number two, the state wholeheartedly agrees we should not have uploaded this to Mexico. That was an error. So that was a mistake that we made in uploading attorney-client privilege to the attorneys in the case. I mean, we thought, and obviously the court is aware we didn't review any of those things. So we should not have uploaded it. But if I would submit there's a huge distinction between if we would have uploaded fee agreements and scheduling matters versus if we would have uploaded a written confession by the defendants to the lawyer.
Come on, it's not that black and white though.
There's a difference in those two things, even if we didn't see it. I think there's a distinction. I think the court can make both rules. I don't know, because I haven't seen what's contained there. I'm just basing on representations from defense counsel that they said there's not anything that important.
Who said that?
So the lawyers have told me that multiple times. Mr.
Oh.
Brody, Mr. Hill, and Mr. Spicer. Like, yeah, most of that stuff's all,
Oh dear.
fee agreement or schedule matter.
Okay.
I don't know, I haven't seen it.
Oh,
I
dear.
don't State attorney's office see it, other than what we read and stuff. I don't know that, sure. Maybe they're just saying that to me, make me not worried about it, I don't know.
Okay. That's all I have.
Thank you. I always say one thing.
Oh my
I
God.
think, this is something that occurred to me yesterday with Mr. Dreiser's argument, and it has to do with the fact that what they're asking for is just to remove the state attorney's office. And that's not a big deal. There's lots of state attorneys, lots of lawyers in front of it. Well, the people of Jackson Beach in Duval County, Florida, have elected Melissa Nelson as their duly elected state attorney. And they want Melissa Nelson to prosecute this case. And Melissa Nelson has deemed that the lawyers that she's assigned to the case, we've already heard about, are the ones that are going to be prosecuting that. And it is a huge deal to remove the duly elected state attorney from prosecuting the case because of what you have heard in this case. That's a huge leap. I'm trying to make that clear.
Great. Thank you.
Clear on the record. The confusion may have been that I said Sullivan, meaning the Sullivan case. The court declined to reach the ultimate sanction of disqualifying the office and did necessary.
You're still proceeding forward and asking for the dismissal of the indictment.
Asking for everything we've asked for. I haven't withdrawn any arguments. I just wanted to be clear. But we've argued what we've argued, and there are several alternative arguments. And I won't belabor that, but I did
I
not
mean,
make
good
that
point.
claim.
Flash fan.
And I'll be very brief, Your Honor. Number two,
Something else.
the courts, the government said that there's no support whatsoever in the cases for my propositions. Ironically, the government cited not one case in support.
That's what I said. Thank you, sir. He noticed it too, right? I agree. He's like, dude, Mr. Sullivan gave us case after case after case after case. And like I said the same thing. I'm like, why is there no case law? It's so weird, right? That's the whole point. You can't just make stuff up. Like, it's bizarre. I mean, somebody else did that. Who was it that did that? In another case recently. But other than that one person, whatever it was from, you never hear that. And it's really, really, really unusual. Might have been Carrie Morrissey. Anyway, yeah, to not give any case, not provide any case law.
It's, but there's one thing I can do, that's read cases, and I am quite confident that if Your Honor reads Castro, Bogle, Fernandez, and Downs, that the court will, and Sullivan will see my position, and I won't repeat it.
Oh no, you know who it was? I just remembered who it was. It was Mr. Owens. It was when something with Sarah. I don't remember which thing it was, but it was one of Sarah Boone's somethings. And Mr. Owens didn't provide any case law. And you know what Judge Kranick said was, well, if you don't provide any case law, it's like if you don't provide any case law, I have to go with whatever the other party said, regardless of anything, because they provided case law. That's the whole point.
I'm unclear about the way in which, at least in this jurisdiction, the government makes representations. Government said all of my cases were about stocks and
right. Yeah, I know. I was like, what?
SEC and nothing to do with these cases. And perhaps the government misheard which cases I cited.
Oh boy.
Downs is a murder case.
Nice.
Bogle is a murder case.
Nice.
Castro is a murder case.
Nice.
Sullivan is an IRS case, but I'm quite unclear the good faith basis upon which the government made the claim that all the cases that I cited were essentially financial crime cases that are not opposite to what's here. The third point, very briefly, the government in its response seems to want to draw a distinction between law enforcement and the state's attorney's office. As soon as the state's attorney's office learned this from law enforcement, we did X. That completely misunderstands notions of unitary government.
Right.
The law enforcement is part of the state.
Yeah.
It is like coming in for a Fourth Amendment suppression argument and saying, well, the state's attorney's office didn't know anything about the police officer abridging someone's Fourth Amendment rights. Therefore, no sanction. That something doesn't make sense. The law enforcement is part of the government. Every agency of the government is part of one government.
Yeah.
And there was a long uninterrupted line of cases, as Your Honor knows, both state and federal, in support of that proposition. The government says that, in response to your questions about the iCloud, which I think were correct, when you pull things from the cloud, they include all the things on your phone and maybe other things. They say, well, we had no reason to know other things were on there. I would point out to the court, well, this was after the agreement was made that the government never asked us. I wasn't part of the case at the time, but previous counsel would have said, well, indeed, everything is up there. It should be subject to the Taint Team as well. The government made two huge admissions. One, the government said that they were, quote, generally aware of the contents, end quote.
Yeah.
The contents, Your Honor, generally aware of the contents, but he said we didn't read it. Well,
I wonder if the second, he said there were two things. I wonder if the second thing is going to be when he said, sure, we should have done it differently, that part.
Someone reading the contents to you or providing a summative statement of the contents of attorney-client privilege makes no difference. That is an affirmative breach of the attorney-client privilege, and I would ask that the court hold the government to its admission. Second, the government quite remarkably said the law enforcement had possession but did not look. If Your Honor reads these, I'm sorry, let me retract that. once the court reviews the cases we've cited, we are confident that the court will come to the conclusion that that is the problem, that the state cannot be in possession of these things. That is what the Taint Team is designed to do. The government said, Mr. Nazario, there's no way Mr. Nazario could tell which things are privileged. There are two responses to that. One, either they or the Secret Service should have provided training as for him to tell. But second, and most importantly, he should have known one way not to talk about or review the general contents, to use the government's words, of putatively privileged material. One way not to do that is to go ask the government. And that just, so you will also see in the cases I cited, Your Honor, that the federal courts, and see Sullivan, this is why federal courts say, and some jurisdictions won't even allow, I did not look at this circuit, non-lawyers to be the decider on the Taint Team.
Right.
And that's for good reason. So Agent Nazario consulted a lawyer because he wasn't sure. The problem is he consulted the lawyer who was also the prosecutor on this case.
Right.
Now,
yeah.
The government, I think, misconstrues the argument on misconduct and use words like nefarious, etc. Conduct is willful, or the standard is willful.
Right, willful,
and
yeah.
to the extent the government acted willfully, that's enough. We don't need to bite off more than we can chew. I've got ideas about that behavior, but willful is enough to get us to a conclusion.
Yes.
And Your Honor, the penultimate point here, in the government's attempt to somehow suggest that there's a difference between law enforcement and the state's attorney's office, in addition to that being antagonistic to the long and unbroken line of doctrine and antagonistic to any competent theory of the unitary government, if we just go to the agreement itself, and I think it's at exhibit number 4, footnote 4. In this agreement, and I'm quoting from the agreement, the state has agreed that any communication protected by the attorney-client privilege will be removed from the devices by a non-state third party prior to downloading.
And so that's the agreement they made, and they breached that by at least 2 ways that I can think of, which is one, be removed, because that ended up not happening. We've talked about that before. And the second thing is the non-state third party, because again, that's what the distinction they're making is that this is law enforcement, it's part of the state, it's not just a neutral third party.
Here's the line I want Your Honor to pay particular attention to. It goes on, quote, in this way, law enforcement officials will not be able to view the content subject to the attorney-client privilege.
Yeah, that's another great point. They were able to view it. I mean, they
specifically,
that's a good point that has not been made yet.
Contemplated that law enforcement will not be able to view, not actually view, not look at that, not be able to view the content. And
really,
this is because
the thing is, the state made these agreements early on that are what they should have done, right? These agreements were really good agreements, but see, now it's almost like, now they've got it in writing that the state agreed to it and didn't do it, right?
we know the government knew at the time when writing this that if you're able to view it, it's impossible to police whether or not they were actually viewed. So the Taint Team was set up so that law enforcement was not able to view it. This was February 27th. Everybody was there. State was there. Secret Service was there. ATF was there. And the police, which is part of the state, was there. I find it remarkable that the state seems to be implicitly arguing that the police department is not part of the state. They're somehow different from the state's attorney's office. And there's, for this sort of motion, I respectfully suggest that there's no doctrinal support for that sort of claim. So they all agree that they can't touch the phones. Police would not have, law enforcement officials will, quote, not be able to view content subject to the attorney-client privilege. That's a string of emails. So the government said, well, Stifler wasn't on the email. Well, this agreement they signed, law enforcement, they were on it. They could view it. They would be able to view the content subject to attorney-client privilege. This expressly violates the very agreement that the state signed on to. So they got all this information and circulated it. We suggest reviewed it, but the court doesn't have to get that far.
He's taking notes.
In part of the theory that we put forward is that the state when one of the co-defendants was arrested, that the state was watching for a reaction that included whether my client would contact an attorney. So government made a proposition that is incorrect under law.
Wow.
That there's no way the very fact of a conversation with an attorney is privileged. That's absolutely wrong. And it's wrong under Florida law because I've researched it and I can get it to the court. It's in a different context. But sometimes the fact of that someone retained an attorney is relevant and it is protected by the attorney-client privilege. When someone retains Ronald Sullivan, sometimes that is privileged because if you retain me, then you're in some legal criminal jeopardy most of the time, and pre-arrest, that may be something that you don't want to know. But the law's clear on that. The rules of professional responsibility, both in this jurisdiction and the ABA model.
ABA model, we've gone over that.
Circumstances that may be the case, even if the general rule is to the contrary. So the sort of broad sweeping claims that the government makes here are not opposite, and I would just ask the court to kindly review the cases and to save Your Honor's law clerk some time and not to
Wow.
the tree, if I may, approach the clerk. I'm handing the court a copy of Sullivan, which I suggest is a good analytical framework for the constitutional dimensions under the 5th and 6th Amendment, such that the court may.
Your Honor, about the petition that
Oh.
I was communicating with my client, the camera was zoomed in towards us.
Oh, it did.
Writing something.
Okay.
It did. I don't know how he figured that out so quickly, but it did because I just commented on it and I was like, oh, look, she's taking notes. And I actually thought to myself, I didn't say it, but I thought to myself, boy, you could probably almost see what she's writing down. I should have said that out loud because wow. Yeah. Holy mackerel. Ruh-roh.
Okay.
Don't zoom
At
in.
what point, Mr. Vice?
I was just communicating for writing.
Yeah, it was just like 30 seconds ago.
Just now.
Okay. If the camera man don't zoom in while they're trying to communicate, just that is still considered private, though we are whispering.
Like, please, it's like we're gonna have another issue with attorney-client privilege on top of all this.
So that's not to be broadcasted, right? Right, thank you. All right.
You can see her notepad.
So that was it, Your Honor. I handed Your Honor Sullivan, which I think is a good analytical framework for the constitutional.
Oh, I guess what they were saying is that they were whispering and that worried you could hear it. Okay, I thought it was really more about her notes. I mean, which makes sense, right? Because, they could be writing things down that actually are like passing notes to their attorney. We see that all the time. Other times there's doodling. We saw that with Ezra McCandless, where she was doodling. And so it seems like there was no issue. Now, having said that, the camera person, they probably just shouldn't do it at all, right? Because there's no way for them to know ahead of time. Just like with what he was saying, there's no way for them to know ahead of time what they're writing down until they already see it, right? So probably best practice is to not be zooming in at all.
Arguments that are implicated by violations of the attorney-client
You guys and your chicken are really fun.
that we have detailed. And I'd like to thank the court for its time and for serious consideration of the issues brought forward. Obviously, if the court has additional questions.
I neglected to ask the lawyers yesterday, based upon pleading, how you view the violation of the agreement in context of your.
That's so funny because I was just talking about that. And I was like thinking to myself, I wonder if the violation of the agreement is a whole separate argument because I bet it is. That's a whole separate thing. But I think that could be a really good point to make because I was just pointing that out, right? They made this agreement and they reneged on all of it. So
Arguments. If there was a breach of agreement, how do you believe it impacts?
breach of contract, civil suit.
I think that a breach of the agreement is a separate, independent
I just
basis
said.
for
That's what I
the
just said.
court to levy a sanction. So I think it's independent And it
So
also,
do they need to have another hearing on that?
in addition to that, I should say, it reinforces some of the constitutional arguments and is evidence for the willful standard for the court to both find a violation and impose a sanction, because it shows that these sorts of things were contemplated, but certainly not followed.
Okay, and are you arguing that to the court as evidence of misconduct, or are you seeing that as something separate?
Both.
The fact that she brought that up, see, again, I commented on it, but the fact that she brought that up, it's almost like, hey, like I think it's really, it's like signaling, right? Because they didn't, she's like giving them that opportunity to give an additional grounds for some sort of sanction, right? Like, and that was her suggestion. And it shows that she's considering it, you know?
It's
I think.
evidence of affirmative misconduct as well. So as an independent argument, I think the court can sanction based on that and find the sort of a willful conduct, call it misconduct, but willful conduct based on that. And based on all the other arguments.
Yeah, that's like another good point. The fact, in terms of the willful part, right? That's a really good point. The way you could kind of merge the two is because here's what I would do. So because Mr. Mizrahi has kept saying it wasn't willful, it was accidental, right? He said that a bunch of times. But this is another point too, where to tie it in, because there's been other examples of the willful, but I'll tell you what trumps all of those in my view is when you tie it into the agreement that they had, and there's like tons of written examples of that where they made these agreements. If you tie it back to that, then now you've gotten to willful without even the rest of the argument, because they willfully broke the agreement that they knew, that they agreed to several times in writing. Yeah, there you go.
The agreement is also evidence of the other argument. And by evidence, simply mean just what say the federal rules say, that it is information that tends to shift the probabilities even slightly in our favor of some material issue in the case. So it can be used in both ways, if I'm understanding the question correctly.
Do you agree factually that the agreement only covered cell phones? Should it be extrapolated to the cloud?
I think it should be extrapolated to the cloud. To say it only agrees applies to cell phones ignores that a cell phone is a vessel through which a host of electronic data flows through and is housed. Only a bit of it is housed on the device itself, much because of storage capacities. We all know, the government knows, is stored on the cloud. So to say that there is a distinction between the cell phone itself without reference to the information contained both in the cell phone and in the cloud that can be drawn immediately from the cell phone is to, one, misunderstand the technology with respect to the cell phone, and two, is to articulate a definition so narrow as to border on the absurd. So I don't think that that argument is was well put yesterday.
Okay. All right, thank you very much.
Thank you.
I think the second is the date. Is that acceptable?
Yes, Sean.
May 2nd.
Well, let's see if anything else. They might just do scheduling.
Do you need to check more on if you need to?
I've had myself in the office, but I believe it's good. It's certainly something, even in the next 48 hours, I should find something off.
Sure, thank you. All right, so the next court date will be May 2nd, 9 a.m. We'll have a motion. Thank you all for your time.
Okay, so there that's so now we're going to go on to the next one. Do 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 do. I've got it ready to go.
Castro makes a distinction
Oh,
between
this is where the court feed starts, by the way, guys, like where they're already talking.
case where there is some governing law that says that a state attorney's office can be isolated in certain respects where a particular prosecutor is removed, but not the entire office is removed. And there's a body of case law. We went over that, and I'm not going to rehash that at all in this argument. But in the Castro case, they found that that body of law did not apply. And they read, however, we cannot say the same result should follow where the defendant or the public at large is given reason to believe the judicial process has been compromised. Our judicial system is only effective when its integrity is above suspicion. And I want to highlight the words used already in this opinion, because the reasoning is suspicion and the public at large has been given just reason, okay? And then it says, our system must not only refuse to tolerate impropriety, but even the appearance of impropriety as well. An imagined advantage on one side or the other in a criminal proceeding can be as destructive of the integrity of the process as can be a real advantage. So if you go back through what has happened in this case, the public at large and Mr. Fernandez especially cannot walk away from this without suspicion.
Also, this is the one that had the more issues with the things in the court feed, by the way. It's kind of annoying, you know, but it is what it is. This is the hearing, and this is before the ruling. They have this hearing and then they have the ruling. So, yeah.
That the integrity of this judicial process has been compromised. A email with what we deem are privileged information was forwarded to other members of the state attorney's office.
This is from May 2nd, because remember when they were doing the scheduling, they were talking about May 2nd. This is from May 2nd.
And I learned today, and sometimes when you're the litigator, you don't absorb all of the testimony. I did not know until Ms. Stifler was on this morning that it was a possibility, or now perhaps even a probability, that Lindsay Butler had read her the entire document.
Okay, so this is what happened is they learned more information. So they had already had their whole thing, and then they learned, he just said he learned it this morning, right? That there was more, and you know, we heard them say this before, right? Where they were like, there was still more information coming in to the extent of this. So they got even more information that makes it worse, basically.
The idea that she hadn't laid eyes on it. I mean, her testimony, and I had the advantage of re-listening to it, was that she said, I never laid eyeballs on it. I didn't read it. That is it's irrelevant. That's like someone saying, I didn't look at it, but call me immediately and read the entire thing to me. It's the exact same thing as reading it. There is no difference between someone being read the document and reading the document. So respectfully, as to whether she read it or didn't read it, it was read to her, or at least her testimony was, it may have been read to her in its absolute entirety, or perhaps just enough for her to determine it wasn't important. And then when she forwards it to Mr. Mizrahi and she forwards it to Mr. Wingard, there's nothing in the body to suggest that they should not read it. And Mr. Mizrahi says that he has not, but that's not the standard. The standard from the Castro case is the appearance that he may have read it or could have read it or forgot. I mean, there is a lot of information in this case. Mr. Mizrahi mentions that there's a lot of information, and he candidly told the court that he didn't recall receiving this document. Or maybe he didn't recall reading it. But who's to say he won't at some point recall how it could be useful? How him knowing what Mr. Fernandez told us in a timeline could be useful to their prosecution. There's no way for the court to determine that. And that's why the standard is not whether they intend to use it, whether they used it, whether I can prove perhaps the detectives or other members of the state attorney's office read those documents. I can't always do that, but that's not the standard. The standard is whether or not the public at large believes the integrity could have been compromised. And with that, Your Honor, what we have put in our PowerPoint is whether or not the prosecutor personally assisting in any capacity, which of course Ms. Stifler is assisting, Mr. Mizrahi is assisting, and Mr. Wingard is assisting, in the prosecution of the charge, it would call for the disqualification of the entire firm. Thank you.
Thank you. Mr. Cody.
Your Honor, it's Ms. Gardner's position that exhibits 18 and 19, as well as the testimony we
Now
heard.
we have more defense argument, but this is counsel for Ms. Gardner.
They demonstrate this continuous course of conduct by the state that has shown a lack of concern for these defendants' rights. We want to remind the court that in February, there was this court order that ratified the use of the Taint Team. On February 27, 2023, there was a meeting with all the players on the state's team about the devices and the taint process. that included the state attorney's office, the Jacksonville Beach Police Department, the ATF, and the Secret Service. They were told they could not go into devices without the Taint Team reviewing it. They then went out and got these defendants' clouds. And you had the testimony at the last hearing from Ms. Stifler that on or about May 11, 2023, she becomes aware that ATF analyst Butler is reviewing Ms. Gardner's iCloud iMessages. And Ms. Stifler was clear to this court. She told them to cease and desist. She made herself out to be this protector of rights and this good actor, and that the state was very concerned about protecting these defendants' rights. And that is May 11th of 2023. Well, what do we know? And what was added to at this hearing today is that the next month in June, the state attorney's office is determining themselves whether or not the privilege applies for Mr. Fernandez. And then they are forwarding docs to each other that are titled confidential. And then, according to Ms. Stifler, she was read the timeline doc, but didn't read it herself. And I submit, Your Honor, that that is a point without any distinction whatsoever. And the fact that the state even tried to make that distinction to the court, that it was read to her, but they didn't read it themselves, Your Honor, shows that there's nefarious conduct on their part, and they know it. Overall, what this court has heard over the days of these evidentiary hearings is that the state engaged, and by state, I mean their team, including the ATF and the Jacksonville Beach Police Department, engaged in reckless and grossly negligent conduct, and there is a clear appearance of impropriety that warrants a remedy. And we gave the court some options for those remedies. We believe that at minimum, the court should exclude Ms. Gardner's iMessages regardless of the source, as that is at least a proportionate sanction for their reckless and gross negligent conduct with regard to handling information
Remedy, sanction.
that they knew contained attorney-client communications. Thank you, Your Honor.
Thank you. Mr. Mizrahi?
Yeah, first of all, with regard to Ms. Gardner, again, just to reiterate, we have never, ever laid eyes on any attorney-client privileged information in that case. And as soon as we found out that police officers were going through things that could be potentially attorney-client privilege, we stopped it immediately and put it through a Taint Team. With regard to the arguments that both counsels made about the state arguing that hearing about the contents of the timeline and reading about the contents of the timeline were arguments that the state made, I must have not been present. The state has never made that argument because we have told the facts of the case, which is that Ms. Stifler never read the timeline, but we never uttered an argument saying that that was a distinction. We acknowledge that Ms. Stifler has the information contained within the timeline as she does with regard to the text messages between the defendant and his co-defendant. So that's not an argument we're making. What I would point out is that the remedy that the defense is asking for is so burdensome and onerous on the state of Florida for a number
Onerous, that's a word you don't hear every day.
citizens in this jurisdiction have elected Melissa Nelson to be their state attorney to prosecute these cases. And removing her is obviously the court has the power to do it. It has to be very cautious in the judicial branch affecting the executive branch and the legislative branch, which you have the power to do. You have to be careful to do with the separation of powers. Number two, Ms. Stifler has worked thousands of hours on this case, and no one could ever replace the amount of.
Not a good argument to make here.
Whether it be within our office or from a different office. And that would be a loss to the citizens of this.
He's just repeating what he's already said.
The email that we sent finally today, or last week, about the receipt, I agree with Mr. Dreiser that the whole point of seeing that email was to indicate that those documents were forwarded because the state had represented to this court that we had not reviewed those documents. I still maintain, and I've been discussions with Mr. Wingard, neither one of us has a memory of ever reviewing those documents. But certainly they were forwarded to us, as is countless numbers of bits of information that are in this case. So I don't see a situation under which Ms. Stifler could be removed and other people in the state attorney's office could not. We discussed this case over the last years in roundtables and discussions, and we acknowledge that bits and pieces of information are passed around that we may have no memory of. And as I say here today, I am confident that I have never read either one of those documents, but certainly they were forwarded to me, they were forwarded to Mr. Wingard, and there's a possibility that they were open. I'm trying to figure out forensically, we could not at this time. But regardless, our arguments are that they're not privileged. These are, again, documents that contained in the Google Cloud. They were not attorney-client communications. And even if they were, the remedy is not to discharge the state attorney's office, but perhaps they are not admissible pieces of evidence. And that's something that the court will decide. Unless you have any more questions, that's all I have.
So there's basically, based on the board, there is a concession by the state of Florida that information was at least available and potentially communicated to Ms. Stifler. And so you think, based upon that concession, you're not saying that there shouldn't be any remedy for the defense. Your suggestion is suppression or exclusion.
I'm saying, suggesting there should be no remedy in this case, number one. Number two, yes, because again, I'm not privy to whether it's attorney-client privilege, and they claim they are. If the court determines that they're attorney-client privilege information, and the court determines that is a fact in this case, then certainly the court can suppress the use of those pieces of evidence. So that is certainly a remedy that would make sure that the public is confident in the application of justice.
So address the argument made by the defense that the appearance of impropriety, how would that ever be remedied by mere, because if it was communicated or if it was potentially known by the state of Florida, how would mere exclusion rectify that?
That's where the totality of the facts of this case come in, the countless hours and the countless effort that the state of Florida did to protect defendants who were not under arrest, who had not been charged, who had gone out and hired lawyers, that had used devices that were sharing information with the entire world.
Waving his hands around.
And
So
then using
melodramatic.
the attorney-client privilege somehow as a sword to prohibit the state of Florida
This is what he
from going
said.
through potentially incriminating evidence is not violating the public trust in any way, shape, or form. We did everything we could to ensure that we did not look at attorney-client privilege.
I mean, the thing is this.
Two documents only, let's be very clear, the only two
The thing is
things.
this. We are the public. I mean, have you guys heard of anyone who's been watching this that y'all know of who are like, yeah, no, it's fine? Because that's not my perception. My perception is the public is like, yeah, this is shady. So he shouldn't be speaking for the public if he doesn't know what the public's thinking. In my opinion.
Things the state of Florida has ever looked at.
Oh,
These
good
two
night,
documents,
Aaron.
One was read, one
You
was
have a good
looked at.
sleep.
That these two documents were not in any communication whatsoever that we were aware of. They were saved into a Google Drive.
God, this dude is a broken
They
record.
were labeled not attorney-client communications, they were labeled confidential and confidential. And so how can the public then say, well, you should have known that these documents in the cloud were attorney-client privilege? Well, we discover later that they're attorney-client privilege, just like if you served a search warrant in a house and picked up a document and said, oh, we were looking for the contract for this murder, but this is a contract of an attorney and a client. We looked at it, we read it, we put it down, the court says you can't use that. That doesn't disqualify an office. So that's the distinction. The court can support the public trust if this is attorney-client privilege that we were not aware of, suppress it.
I'm going to go to the case that Mr. Sullivan cited at the last hearing, while not reported, while a federal case. The Sullivan case seems to suggest a method for review of potentially
Does it come back? Is that it or does it come back? Let's just see. Oh, it comes back. Okay.
or according to the Sullivan case.
That was
the
a longer.
procedure is presented to
Okay, let's go to it.
how
There we go.
you agree and gave the defense the assurance that
Yes, the
you
agreement.
did not even look, which
Yup.
I'm not even saying that agents couldn't have if they were outside the jurisdiction and followed such a procedure, even though
Agreement.
Sullivan, the court is critical of that process. Explain to me and reconcile for me, you just argued to me that by stating
She says, explain it to me. You just argued with me or to me, but please explain to me.
whatever these documents are, either attorney-client privilege or not, they are in fact sharing it with the world. Why would the state agree to a heightened standard, not review, but then potentially search without any reference to a Taint Team or anything? And then, are you making that distinction that because it was saved on a Google Drive, that you all could just operate as your own Taint Team? Is that what you're saying to me?
Well, first of all, yes, we could have done all of these. We could have searched the phones without this agreement.
Right.
But we tried to do something better, which tries to get to save the public trust. The problem is that we were doing two different things. So when we had this, as they referred to, a ratified agreement on the phones, that is what law enforcement thought. Oh, this is to the phones, and we did that whole procedure. When we did additional searches on the clouds, it did not occur to them to do that. Or to us initially.
Did it occur to the state?
It did, as soon as the state was aware that they were searching these without the Taint Team, we stopped. The answer is yes, it did occur to us. But I do
In
think there's,
federal court, according to the Sullivan case, the taint procedure is presented to the magistrate who approves the warrants. So the warrants were going through the court system. The warrant would include what would be on the devices. My understanding of the testimony from the Stifler is the devices potentially more, and that's why the state was going for it. That it would potentially contain messages that might have been deleted from the devices,
specifically
themselves.
the ring camera footage and
Ring.
yes, that's what we're looking
Things that were deleted, or things that were beyond what had been agreed to the devices. So I'm trying to reconcile like what the argument is that, are you saying because it was on a Google Drive that the taint agents weren't applicable from the state's perspective?
There was never a court order with regards to this. What I'm
Right,
saying,
because there was an agreement between
Correct.
parties, and it was in a footnote.
correct, as to the phones. All I'm doing, we never wanted to say, hey, we're gonna search the Google Drives or the iClouds to try to do an end around to this agreement. That was never the intent. It was a distinction. And that distinction led to the police searching the clouds. And then when we became aware of it, we stopped it. It's as simple as that. This was not an end around to try to get around the phones. And again, that's the whole point of this whole concept of prejudice. What prejudice is there? What evidence is there that we're going to use in this prosecution? What knowledge do we have that's going to change any of this? This is unlike federal cases where they're serving. This is a unique situation where we're investigating a murder case and the people have hired lawyers. And then in today's world, we have this Google information that stores everything. We're trying to find probative information, which we did. In those deleted Google clouds, we found very probative information in this case with regard to the planning and plotting of the murder of Jared Wright.
Okay.
And that is, this is a balancing test of the state's interest and the interest of attorney-client privilege, and we tried to do both. We did the best we could.
Okay, and the distinction, I just want to be clear, so the distinction is that you believe the agreement was only to the devices because, and if I'm understanding the timeline, they knew about the devices because warrants were served, the devices were seized. However, the defense would never know about the state's investigation into a cloud because those things are specifically not communicated to defendants so that they don't go and delete things from the cloud. So they would not, that is the defense, would never have the ability to seek the protective orders that they did for the devices because they had no knowledge of it.
Correct, that's all
So
true.
then it would be incumbent upon the state, right, to operate under the prior agreement because you potentially knew that it contained things from the device.
Correct. I will say it would be incumbent upon us not to look at attorney-client privilege. And we did not look at attorney-client privilege. Whether it was incumbent on us to set up the same Taint Team is, I think, up for debate. Should we have done it earlier to make sure of? That's a good argument. I think you can make that argument. But I don't think it's definitive.
All right. Thank you.
Thank you.
Your Honor, there was some discussion about a next court date on the 9th. Do you recall that?
Yes.
I think parties were going to request the 13th for availability reasons. Is that something the court would consider? Or is that not right? Did I misrepresent that? Okay, I thought, sorry. What day? Mr. Carodi is not available on the 9th, and
Okay.
I'm visiting someone in prison on the 10th that it took like 3, I can't
Okay.
reschedule.
No
We
problem.
could come back the 9th for Fernandez and the 10th for Gardner, or the 13th is not okay?
It's fine, it's the first
Oh,
I thought we were gonna
okay.
split 9 and 10.
Or we can all come back on the 13th.
I will do whatever you want to do. I'd rather do it together. What about the 8th?
Mr.
No, Your Honor, I'm out of town until the afternoon of the 9th.
So Gardner was driving a little bit of this, that you wanted time for the bond hearing.
Yes, Judge.
Give me just a minute.
Carrie, that was done.
Yes, Your Honor.
On both cases, that is, Mr. Fernandez and Ms. Gardner, the case will be set for on the motion. Start that. On Mr. Fernandez, the case will be set for May 13, 9 a.m. for the motion. For Ms. Gardner, it will be set for May 13, 9 a.m. for the motion, and hearing on motion to be set.
And I know it's a little early from the 13th, but the parties did discuss availability of Wednesday the 15th for that hearing.
I can let you know.
I think they're just going over the scheduling because 13th is the next one. Let me see if there's any.
I'll let you
Okay, that's it. All right, let's go on. So now for the ruling. Okay. Got this ready to go. Here we go.
First, number 6, number 9, your calendar.
know. Thank you.
Good morning, Your
Mr.
Honor.
Fernandez and Ms. Gardner.
My name is Jesse Dreiser. I represent Mr. Fernandez, present at the sitting council table behind me. I'm also here with Frank Stoney.
Thank you, Good morning.
Good morning, our pastor, on behalf of Shanna, Gardner, President for Mr. Wise and Mr. Sullivan are on Zoom.
Okay, thank you. All right, we are here for rulings on the motions that have been filed. And this call.
Yeah, so for anyone who's maybe joining us, this glitching is from the court feed. There's nothing I can do about it. I know it sucks, but we will still hear her.
Motion to disqualify the Fourth Judicial Circuit at the State Attorney's Office. Additionally, the adopted
You did a great
motions
job.
and her own motions, that is, Ms. Gardner's motions, to adopt, supplement the arguments filed by Mr. Fernandez. And this court has conducted hearings on these matters, and I am now ready to rule.
Okay.
First, let me say that the weight of this decision is not lost on me for either side. And for the defense, this court recognizes that attorney-client privilege is one of the oldest and most sacred privileges. And in my order, I have quoted the Fourth District, where they said, it is therefore not only an interest long recognized by society, also one that traditionally is deemed worthy of maximum legal protection. And so that weight is not lost on me.
So okay. I don't know what she's going to say. I appreciate you guys who aren't spoiling it. I have a feeling she's going to deny. Well, I think it goes out saying she's going to deny things in part. Like if it were me, I would say there's no question you have to remove the prosecutor. She's already testified as a witness. Get her out of there. And I do think suppression of some of the attorney-client privilege materials, even if it is scheduling or whatever, just suppress it. They can't use it, even if they, whatever, right? Just in case. While I still think it probably is warranted to get rid of the state AG's office, I don't think she would do that. So, because the motion can be, in other words, I guess technically the motion is to remove the office, right? So I would expect her, I'm trying to think ahead. I would expect her to say the motion is denied in terms of that. But then of course there's the additional, remember they gave those compromises. So there could be those other remedies she goes for. So maybe that's where she's headed. However, her languaging here almost sounds like she's going to deny it in its entirety. And again, but I can't, don't spoil it for anyone that knows. I'm trying to figure out in my head based on her demeanor. Like, in other words, it almost sounds like she's like, the way she's saying, I understand how important it is. The attorney-client privilege is sacred. It almost sounds like she's giving them condolences by saying that, which is weird because it's almost like, that doesn't match the content of it, right? Because what she's saying is should be the opposite. It should be like, yeah, it's those sacred things. Like, duh, I'm going to grant your motion, right? But I'm getting the vibe and her tone that she's saying that, but it's out of I don't know. Do you guys know what I mean?
And equally as important is the prosecutor's role. In a criminal prosecution, that prosecutors are held to the role and responsibility that goes beyond that of other attorneys. The allegations that have arisen from the motions filed by the defense are serious, and the remedy that's sought is extraordinary.
Mm-hmm.
This court has the authority to disqualify the entire Fourth Judicial Circuit State Attorney's Office.
Right.
It is a drastic measure, and the higher courts in the need have cautioned courts not to use unless it is absolutely necessary. This court has gone through the analysis of both actual prejudice.
And I have to
substantial
say something
misconduct.
else. If you're a defense attorney, what she just said, they know. When she said the higher courts than her have cautioned her against using it because it is such an extreme, the defense attorneys know that. Think of it this way, right? You know, like if you're going to go in for a raise or whatever. I mean, I've never been in this position, but like this is what you see on TV. This is what people say. You know, you ask for more than you think. So, for example, if you think that they're going to, you know, maybe an appropriate raise is, I don't know. If you're getting, let's say that they'll say that your salary is, I don't know, I'm just gonna make it easy, $100,000, right? Let's say it's time for a raise, and you know, if you had to try to guess, you would think the appropriate raise or whatever was like 120,000. I don't know, I'm just making things up. Then you might ask for 130,000, right? Because if you ask for 120,000, they'll probably knock it down to 110. Similar thing. So these attorneys know that this is an extraordinary measure. Now, if they ask for it, they could still get it. But if they ask for it and she denies it, then that gives them the opportunity. Remember, they have all those other, like I'm calling them compromises, right? But they're the other remedies. So even if they think that that's that one of, let's say the remedy of removing the prosecutor, even if they think that that's what she's going to do, or even if that's what they think is the correct and fair sanction, the way you get there though is by shooting for the moon. Ask for her to remove the, see what I mean? Because then it knocks it down to the next lower remedy. Hopefully that makes sense. So I just wanted to say that, you know, the defense isn't being rude by asking for that. And she knows that. Like, it's not like she's saying you guys asked for something unreasonable. So yeah.
I have poured over the facts that have been offered both through exhibit, evidence, and testimony. Based upon that very thorough review, the court finds that disqualifying the judicial circuit is denied. While I will say,
That's what I expected.
Mr. Fernandez stands uniquely and factually different than Ms. Gardner's allegations and what was substantiated by the evidence. The two documents, that is the timeline and the text messages, the court, through its in-camera review of the timeline, does find, okay, that is an attorney-client privilege document.
Okay.
There is no evidence that the state of Florida has opened it or intends to use it. Therefore, actual prejudice cannot be substantiated by the evidence. The text messages do not bear the same hallmarks of the timeline, and the court finds that the text messages are not attorney-client privilege. So then I turn to the substantial misconduct. The taint procedure that was to by the state defense, the defense brought it to the court's attention through a motion, pre-trial and pre-arrest, pre-indictment, warning the state of the type of evidence that you were about to embark on. It was an agreement that was made to a higher standard.
You know, like I said it, I called it earlier. I was like, she's signaling here because she brought up this point. This wasn't something that was part of their initial argument, and it probably should have been. It almost seems like to her, this is the worst thing that the state did, that they had an agreement and they didn't follow through. And I agree. And you know what, the thing about that is in that agreement, it doesn't actually matter if they viewed any of it. It doesn't matter if they intend to use any of it. The agreement was that they would, okay, what was it? I outlined it earlier, but it was like that they would not even know about it, right? They wouldn't even know about it, and that it would be deleted immediately. And there were like a couple other things that were part of that agreement that, and I think it was even something like a taint team. I think they specified. Anyway, there were a number of things, and they violated all of that. And the thing is that whether or not they did or didn't see anything, whatever, that's irrelevant because they could violate that agreement without actually knowing what the content was. So yeah.
And require a law, quote unquote, content line review.
Right, content
that
line.
is not needed.
Right, I just remembered another part of the agreement where, right, it was a non-state third party, and that also didn't happen.
The state could have employed the procedure suggested by the defense. It chose not to.
Mm-hmm.
That set the state on a series of actions and poor judgment decisions.
Yes.
To engage with officers that were
either
tasked to taint review or officers that were viewing untainted materials. The state's actions left itself open to a high probability that attorney-client privilege information would be exposed both to law enforcement and to the state without proper review. The court finds that the conduct of the state is not necessarily misconduct for a few reasons that I outlined extensively in my order. It was poor judgment. It was a hyper-technical approach to the agreement that you assured the court ruling on the privilege issues, pre-arrest, pre-indictment, and the defense. It only ended up in a footnote because the state assured Judge Carbula at the time and the defense that it would work with the defense.
Yeah.
It did not. So, law enforcement naively, maybe the state naively thought that just by avoiding email folders that it would not review attorney-client privileged information. We know that not to be true because Gardner's, the one instance was Gardner's text message. It wasn't in an email folder. We know that through the timeline, it wasn't in an email folder. So that hyper-technical view and approach to the agreement brought us here today.
Yeah.
The court finds that that is not substantial misconduct because the state, especially in this Gardner's case when alerted, acted appropriately, disabled, shut down, restricted access to a platform, informed defense attorneys. When the timeline and the text messages came up, Ms. Stifler took herself on a course of poor judgment decisions to engage.
We're getting rid of her.
But the timeline was not reviewed, and there's no evidence of it. So, therefore, the state, has not acted in such a way that warrants disqualification. And as I write in order, I'm very solid. While it did not rise to the level of disqualification, it does warrant an alternative.
Yes.
Ms. Gardner argues that the alternative should be dismissal. This court finds that to be inappropriate.
Okay, yeah. I mean, I didn't even think,
Prejudice pales in comparison to what the state did in Mr. Hernandez's case. When Ms. Gardner's attorney-client privilege information was inadvertently reviewed by the law enforcement officer, the state acted appropriately and stopped the review, sent it to the taint agent, and then nothing more was done. Mr. Hernandez, the state engaged, made a judgment call, then got the item sent. So dismissal, because a text message is not attorney-client privilege, and that is what.
I've even been factoring that in, and when I keep listing my compromises, right? I didn't think that. I guess they haven't talked much about that, but it's just also just seems so extreme, like dismissal of the indictment, like that's not going to happen. So this, there's no question that's going to get denied. What I'm really excited to get to is what she says, because remember, she says we do need a remedy. So is it going to be removing the prosecutor? I mean, in my view, it has to be, because she's already, beyond anything else, she's already made herself witness. So yeah, but we'll see.
Never been reviewed by the state of Florida, does not warrant the alternative of dismissal of the indictment. So to the extent that that is requested, that is denied. The court's left with another option. And I draw my authority from the rules 3.220, and also this court's being brought this information in a way in which that this court cannot ignore. The state stands here without any credible argument that you abide by the agreement. The state stands before the court, possession of a text message that it otherwise would not have gotten because it agreed pre-trial, pre-indictment that it would do a quote-unquote content blind taint review, even though that's not required by law. The timeline goes without saying should be suppressed, and it will. The text messages, because of the substantial violation of discovery agreement, this court will suppress that as well.
Okay. So she's not gotten to the prosecutor part yet. She's talking about suppressing. Remember, I said, so what did I say, guys? I said, in my view, the thing that I think would be reasonable here for her is suppressing the certain pieces of evidence, right? And then getting rid of that prosecutor. So we're at the suppressing pieces of evidence part.
So you will not be able to use against Mr. Fernandez a document that you've got in violation of the agreement that you entered into with the defense. Ms. Gardner is also entitled to, and also Mr. Fernandez is entitled to an alternative to disqualification. This court, in examining the facts, finds as though it is necessary to conduct a thorough case management discovery hearing for both sides. I'm left with the fact that I don't know where you all are at with discovery, but I do know that what was happening before these issues were brought to the court is not acceptable. Okay, so the court will be involved, can be involved in appointing, as requested or suggested by the defense, a actual taint team.
Yeah.
That consists of more than one person if needed. And I will gauge that when I figure out where you all are at with discovery. I don't know if Nextpoint is still shut down. I don't know if y'all have even gone through the evidence. But what I do know is that I'm going to order until that case management hearing is set and also completed, and there's a court order about the discovery process. There will be no review of Nextpoint and what the originals were put up and all of those things until I have a good idea that there will be no more errors in exposing attorney-client privilege information. Here are the copies of the court's order. There's one copy of the original, and you can give the rest to the parties.
What about the prosecutor? How does she just left that out? What? I didn't hear anything about, well, I suppose it's possible that it cut out when she said something.
Yes.
Court holding any case management on that.
All right, I'll hold it concurrently on
Okay, so now they're doing
Mr.
schedule.
Fernandez-Saldana. Case will come back before the court on May.
Okay, let me pull something up real quick. Because I have, hold on. I think I have it. Should have it. Yes. Let's take a look here. So we just saw her hand them copies of her ruling. So let me unshare, reshare. So Flash Fan is saying that she stays on. I don't know how that's possible. I don't know how that's possible because even without the attorney-client privilege thing, when you've got somebody who's made a witness, who's a party, like that's I've never seen that where that's just been okay. I mean, that's crazy. I don't know how that's possible. Yeah, I don't know how that's possible. That's what I'm wondering, if maybe she explains that in here. You know, I wonder if maybe the part that's so here, both defendants' motions argue that the Office of the State Attorney for the Fourth Judicial Circuit should be disqualified because assistant state attorneys, ASAs working on their cases, committed substantial misconduct. I wonder if the thing is that while we know that like the whole thing about her being a witness is a problem, remember the judge can't they haven't said that, right? I'm wondering if that's what it is, because the defense team, so far at least, they didn't make that argument. They didn't say that I heard. Almost it cut out, but and it wasn't in their motions. Like there was no talk. Maybe that's what it is, because, and which blows my mind. I wonder if have they argued now she's made herself a witness. I wonder if it could have been a different result. But when you see it here, she's laying out exactly what they said, what they asked for, and it doesn't say anything about her being made a witness. And that's the thing, is she can't just grant something for a completely different set of reasons, right? That's like we were talking about the other night with Judge Belvin, right? It's like they have to make the argument, they have to ask for the remedies, and they have to provide the case law. And so I wonder if that's the thing that they didn't do, because there's no talk of it. That's the thing. I'm the one that keeps saying that, but I've not heard anyone else involved in this case, like these parties. No one's referenced that. No one said anything about that. which just blows my mind. I just wonder if like it was just they kind of expected her to be disqualified and it wouldn't matter. I don't know. Yep, and Bond is next. Correct. Bond is next. Why is there sound? Yeah, Bond is next. I mean, if it were me and I was, I don't know. I would imagine, I think that what should happen is maybe a follow-up, pleading from the defense that's like, motion to have her, removed from the case because she's now made herself a witness. Now, I guess, okay, I guess here's the thing. I guess maybe the way they're working on, like, okay, what would be the difference? I guess maybe the difference is that she's not a witness to anything pertaining to what will happen at trial, right? She's a witness to this specific issue, which is kind of separate and apart from the rest of the case, right? Like this was just something they had to sort out because of these issues with attorney-client privilege, but like, it's not like she's a witness to, I don't know. It's hard for me to even think of an example because I feel like every time this happens, the same result happens, which is the person's removed. So it's really kind of hard to even, but maybe that's why. I don't know. I'm just still surprised that it didn't come up and that no one's made that argument and that no one's filed anything else about it, which is just interesting. I don't know. Because this is just not even going to be mentioned. The other thing, the state called her as a witness, not the defense. I wonder if that's the distinction, right? Although they could have called her. They could have, right? But I was like, I don't know. Yeah, it's weird. But maybe we'll hear more about it at some point. Maybe it'll come back up. I don't know. It is there's the suppression, which they went with for some of those things. Yeah. Ooh, look at her signature. You can actually read her last name. That is unique. I love that her first name is London. That's such a cool name. Yeah. All right. Well, that'll be it for this one, guys. And we will pick up on the next one with the bail hearing and or bond hearing. And I don't know if it'll be tomorrow. I will see what happens. If I get Casey Anthony finished with the next episode, that might be tomorrow, but it'll be one or the other. We'll either start with the bond hearing or we will have the next Casey Anthony episode. And then I know Thursday, there's a bunch of stuff happening. And as I've mentioned, my priority there is to cover the Daubert hearing for Karen Reed, because I don't want to go out of order with these hearings. But I'll probably be doing that night. We'll have to see, because I know I've got some lessons, so I might have to do that on Friday. We'll just have to see. Kind of depends on how long that hearing is. And I wouldn't be surprised if it's quite long. But that'll be really interesting to see, because that's actually the significance of that hearing, by the way, is it gives us an idea of maybe something that might be different with the defense strategy for this upcoming trial. Or maybe not different per se, something they wanted to have happen in the past trial, in the first trial, that didn't get to happen. And, as far as like, are they going to, the whole point is like, they're clearly they're still, they've got the dog bites, right? So we'll see. It'll be really interesting to see how much they want to go into that. I'm sure they're fully aware that many people had said, just you don't need a theory, right? They really didn't, right? The case was, you guys know what it was, but we could have something different with this other prosecutor in the new trial. However, the evidence is the evidence. The solo cups are the solo cups. That's not going to change. And to me, as I've said a billion times, I don't know how you get past the solo cups. So, but anyway, that'll be it for this one. I'm still finishing timestamps for the last night's stream. I think I'm over halfway done. I do have the previous Casey Anthony episode all done with timestamps. And I'm sure I'll be able to finish up with the timestamps for last night's episode pretty soon for anyone who's on replay crew. And then I'll get working on this one as well. But that'll be it for now. So guys, thanks so much as always for being here and being a squirrel. And I'll see y'all next time.